one of Delhi admission.
Wait, please. But I think I should start from the beginning.
Okay. Yes.
But the last time we did synopsis, once again, and
Synopsis.
I'm serving once again to be able to locate them. That fine.
Melody,
You have made some changes in the synopsis, or
no, it's the earlier one. Melody.
okay, we have.
We have. Now, Your Lordship, this appellant has been serving as regular assistant professor and head of the department of computer science and application, Karimganj College, which is affiliated college under Assam University. Now, my lord, he obtained MPhil degree in the year 29/9/2008 and PhD degree in the year 25/2014. Now, my lord, there was an advertisement in the year 2017, and in three of the colleges, Amjonga, Tulungia, and Dalgaon. The appellant, my lord, he participated in all these colleges, and two of the
These are
colleges.
three different advertisements, or
No, same.
one advertisement.
One advertisement.
For all the three colleges.
No, my lord, three separate advertisement. Dated, your lordship will find 8/5/2017. My lord, I will just see to that. Your lordship may see at page 59. It is dated 2nd May 2017. Advertisement for assistant professor for Deen Dayal Upadhyay Adarsha Mahavidyalaya at Amjonga. This is in the district of Gwalpada. At page 59, your lordship will find. These are all separate, my lord. And this, my lord, the post of assistant professor, your lordship will find there is one office memorandum way back on 25/6/2012. What marks they will get, say in HSLC, HSSLC, then PhD, and all these things, MPhil, what marks they'll be given. It is regulated by that particular OM, which your lordship will find at page 84. That is the crux of this case, my lord. At page 84, your lordship kindly see office memorandum dated 25/6/2012. Your lordship will find at page 85, there is a chart down below, distribution of marks. Academic record, 70 marks. So far, academic record, then HSLC equivalent examination, there is no dispute, my lord. Your lordship may turn to page 86. Dispute is in regard to MPhil degree and the teaching experience. Now, your lordship may look at page 86. Research performance, 25 marks. PhD from UGC, my lord, it is not necessary, but I am making this submission to clarify certain things. Because your lordship will find somewhere learned single judge said experience in PhD, which is not in the office memorandum. There is, my lord, maybe some overlapping. Because a heavy, my lord, factual dispute is there in this case. And your lordship will find too much of facts. Sometimes we get overlap with that. So that thing had happened. In PhD, my lord, I am not entitled to get any mark. I did not ask for that. But learned single judge made a passing remark. That's the reason it is required to be, my lord, clarified. Now, your lordship will find PhD from UGC recognized and Government of Assam approved university if the candidate has PhD degree in addition to eligibility requirement of NET/SAT. Now, your lordship may see the next line. There will be no marks for the PhD degree if it is counted in lieu of NET, SLET, SCT. Now, in my case, I did not get this, my lord, NET, SLET, SCT. So I just obtained PhD. So therefore, I'm not entitled to get any marks. And I did not ask for that also. So, my lord, your lordship may skip. Just for clarification, I have shown to your lordship. Then your lordship may see MPhil degree from UGC recognized and Government of Assam approved university. Now here, my lord, your lordship will find MPhil degree, my lord, I obtained in the year 2008. So rightly 5 marks was given by the two of the institute, but one of the institute, why they did not give, I'll come to that to latter part, my lord. Now MPhil degree, 5 marks. Then your lordship kindly come down to teaching experience, 5 marks. Now teaching experience, 1 mark for each completed year of service in an affiliated government degree college, subject to maximum 5 marks. Now your lordship will find I have obtained my MPhil degree way back in 2008. The advertisement, as your lordship has seen, in the year 2017. Now 2008 to 2017, I gathered experience as, my lord, UGC qualified teacher, and total 9 years of experience I gathered. But I am not entitled to get nine marks because maximum I can get 5. So rightly, 2 of the colleges given me 5 marks, but the another college, reason best known to them, they did not. Now, my lord, I'll now
MPhil, there's no issue.
there is no issue, my lord.
So far as MPhil is concerned.
Yes, there is no issue at
You
all.
got 5 marks in all,
No, in one of the colleges, they have given 0 marks,
in MPhil.
my lord.
Okay.
The reason, there is no reason given. The same subject teacher who has given me in the Amjonga 5 marks in MPhil, 5 marks in teaching experience, and the 2 of the Amjonga and, my lord, the other one is Tulungia. They have given 5 marks in teaching experience, 5 marks in MPhil. But so far, Dalgaon is concerned, they have given 0 marks in MPhil, 2 marks in teaching experience. My lord, the same subject teacher. Now, you also will find that there are many reasons. These the director of education and the invigilator, everybody, I do not know what the reason. They were against me. The order will clear everything. Now, my lord, your lordship will find in Tulungia, I obtained the 2nd position. But why I was not given, your lordship will find it. They have said that I have no proficiency in local language. Let it single just set aside that part of the thing. So it is not necessary to argue. But I'm just saying how I have been deprived. Well, how they were always biased. They always victimized me. Even now, my lord. Now, my lord, now I'll take your lordships to the written synopsis to get the factual aspect of the thing. And then I'll slowly take to the necessary annexures. Your appellant has been serving as an assistant professor, and the lordship got that.
Yes.
And head of the Department of Computer Science and Application in Karimganj College as affiliated college under Assam University. He obtained MPhil degree in the year 29/9/2008 and PhD degree in the year 25/2014. Pursuant to advertisement dated 8/5/2017, which is at page 59, in 3 of Pandit Deen Dayal Upadhyay Mahavidyalaya, that is Amjonga, Tulungia, and Dalgaon. In short, your appellant applied for the post of assistant professor computer science. Selection committee of 2 institutions awarded marks to the appellant in terms of office memorandum dated 25/6/2012. That is at page 84. Poem dated 25/6/2012 demonstrates that a candidate having MPhil degree is entitled to 5 marks, and for teaching experience, maximum 5 marks, 1 mark each completed year of service in an affiliated government college, degree college. Your appellant being UGC qualified teacher from 2008, that is year of obtaining MPhil degree till the year of interview, that is 2017, your applicant has completed 9 years of service, which entitle him maximum 5 marks on teaching experience. Selection committee of Amjanga awarded 5 marks to the applicant on MPhil and also awarded 5 marks on teaching experience. That is at page 66. Now, your lordship may look at the page 66. Page 66, that is, my lord, Amjanga, how they have allotted marks. Your lordship will find extreme left-hand side, the name is written Rajiv Das, the present applicant. My lord, Rajiv Das, your lordship will find in the left-hand side. Then in the right-hand side, your lordship will find MPhil marks. He was allotted 5 marks. Then teaching experience, he was allotted 5 marks. This is in Amjanga. And in the small note, your lordship will find not eligible for non-proficient in local language. He secured second position nonetheless. Because of this remark, he was not accommodated. However, learned single judge had set aside this. So, my lord, this issue is no longer there. Now, my lord, then your lordship may look at page 72. This is another college that is called Tulungia, my lord. Now, left-hand side, your lordship will find the name of the applicant Rajiv Das. He secured in MPhil 5 marks, then teaching experience 5 marks. Now, your lordship will find a note in the extreme right-hand side, Bengali fast language, so not recommended. This one also set aside with the learned single judge, because according to the learned judge, it is not sustainable, and rightly that observation was given. Then your lordship may see at page 70, my lord. I am taking to your lordship because of the reason the bottom your lordship will find 2 subject expert. One is Professor Tulsi Bejborua. Another is Dr. Abhijit Sharma. Both are subject expert, my lord. Now, these 2 subject expert given 5 marks here in MPhil as well as the teaching experience. But so far, the other one, my lord, they have given, I'll take your lordship to next. At page 82, there is Dolgaon. Page 82, your lordship kindly see. The left-hand side, Rajiv Das. Then MPhil, he was given 0 mark. Then teaching experience, he was given 2 marks. And that college is Dolgaon, my lord. And the subject teacher, your lordship kindly see down below. Dr. A. Sharma, subject expert. Professor T. Bejborua, subject expert. Same subject expert. Given some marks there, and here they have shifted from there. The reason is best known to them. Then I'll continue from my this synopsis, my lord. The last para. The first page, Government of Assam, the last 3 lines, my lord. Government of Assam has recognized qualifying marks on MPhil degree, the candidate who obtained the same before 10/7/2009. This timing is very important, my lord. Before 10/7/2009, UGC also accepted that position. Notification dated 17/1/2011 and notification dated 1/1/2011 are annexed here to mark as so and so. Main ground of the appellant in the writ petition as well as in the writ appeal is that in terms of OM dated 25/6/2012, applicant is entitled to maximum 5 marks under the head teaching experience. There is 1 mark for each completed year of service in an affiliated college. Your applicant being UGC qualified teacher from 2008 till the year of interview, that is 2017. Your applicant has completed 9 years of active service, which entitle him maximum 5 marks on teaching experience. Now, the single judge did not deal this aspect of the matter and led in error in not considering this factual as well as the legal issue. Learned single judge also did not consider the fact that the same subject expert, namely Professor Bejbarua and Dr. A. Sharma, awarded 5 marks on MPhil and 5 marks on teaching experience in Amjanga to the applicant, whereas they have awarded 0 marks on MPhil and 2 marks on teaching experience to the applicant at Dalgaon. No reason shown at all. Only issue learned single judge decided in terms of OM dated so and so. There to that, the period of time taken. Now here, my lord, your lordship will find, I made twofold argument before the learned single judge. First issue, my lord, so far teaching experience is concerned, since I obtained my MPhil degree way back in 2008, until the date of advertisement, I have gathered experience of 9 years. Although I have gathered experience for 9 years, maximum I can get 5 marks, and it was allotted by the 2 colleges. Now, this submission was, your lordship will find, it was not recorded. Rather, my alternative submission is that, that while as a, my lord, research worker on PhD or MPhil, if I continue my research study simultaneously along with my professional career, my lord, that will also be reckoned. But in this case, my lord, I will say that this part of the argument is not necessary to go into, because of the fact that admittedly, my lord, I am having teaching experience for 5 years and I has allotted that. So therefore, my lord, so for second submission, learned single judge has gone into that. And according to the learned single judge, that I am not entitled to get any experience when I do my research study. And that's a different subject. I will skip that because I have sufficient marks as a teaching experience. The finding of the learned single judge at paragraph 10 of the judgment, stating that respondent number 2 had not committed any illegality in refusing to consider marks to the applicant by treating time spent for pursuing MPhil and for PhD degree as teaching experience, notwithstanding that the petitioner might have actually rendered service to his college during that time. Entire consideration of the learned single judge was not in consonance with the fact situation of the case. When applicant obtained MPhil degree in the year 2008 and has become UGC qualified teacher from 2008 until the date of advertisement, that is 2017, he had teaching experience of 9 years. Therefore, there is no question of reckoning the period, that is time spent by teacher during research study. That is absolutely not necessary to be added. In paragraph 5A of the judgment, counsel of the writ petitioner argued that petitioner was given lesser marks in teaching experience as he had 9 years of teaching experience as UGC qualified teacher, and alternatively he is also entitled to reckon the period of active service spent in pursuing research degree simultaneously with teaching assignment. And a single judge did not give any finding on the first argument advanced by the counsel of the appellant. In paragraph 28 of the judgment, learned single judge sent the matter before Secretary Higher Education Department as to whether the non-granting of marks to the petitioner for MPhil and experience in PhD for selection and appointment as assistant professor is liable to be interfered with. The case of the appellant is that he is entitled to 5 marks on MPhil and 5 marks on teaching experience. There is no provision in the OM dated 25/6/2012 like experience on PhD as held in paragraph 28A. The lordship has seen that OM. There is no column like experience in PhD. My lord, this is only teaching experience. So that's why those arguments were advanced. Likewise, in para 28B, appellant never paid for any mark like experience in PhD. In fact, appellant never paid for any mark under the head PhD. In paragraph 20D, learned single judge failed to decide teaching experience of the applicant for 9 years after he became UGC qualified teacher in the year 2008 till the date of advertisement in the year 2017. It is not necessary to decide whether applicant is entitled to marks for time taken by the applicant to acquire his MPhil and PhD degree by considering it as teaching research experience. This is pertinent to mention. Learned single judge in paragraph 14 of the judgment held in Dalgaon, one of the posts remained vacant. And this honorable court also directed to keep one post vacant for the post of assistant professor. Furthermore, in paragraph 28 of the judgment, this honorable court also directed that if the appointment of the petitioner is to be approved, the authority shall pass an appropriate order for approval and appointment of the applicant, if necessary, by creating a supernumerary post. From the foregoing, it is absolutely clear that applicant is eligible to get 5 marks under the head MPhil and 5 marks under the head teaching experience. And since one post of assistant professor, computer science is vacant in Pandit Deendayal Upadhyay, Dalgaon, the respondent may be directed to appoint your appellant as assistant professor, computer science within a time frame. Now, this is regarding all the facts about Melo. Now, I'll take your lordships to the impugned judgment, which is at page, my lord, 171. This is judgment date is 16/3/2023. The lordship got that. Heard Mr. So and so. Mr. K. Gogoi, learned standing counsel for the education, the respondent number 1 and 2, and MS J. Gayan, learned counsel for respondent number 12. Now, respondent number 12, your lordship kindly see, UGC. Now, they did not advance any argument before the single judge. They did not file any affidavit. None appears for respondent number 3 and 11. Now, why I am saying so? My lord, UGC has filed an affidavit by taking leave of your lordship. Now, legal position is this. You did not contest the case. You did not file any appeal before this honorable court against the judgment. Now, can you advance any argument on this particular point? Why the honorable single judge say the MPhil is not in a question, is a valid degree. Now, whether UGC can advance any argument, I will take your lordship through judgment of the honorable apex court that said that if you had a chance of filing appeal, you did not file appeal, you have missed the bars. So that is the legal position, as your lordship is well aware. The issue staple will come in this method. Issue staple, res judicata, these are same because the public policy demands when a litigation has been ended, you cannot go on by filing one petition after another. Whether you, in a case where you did not contest the case in the writ court, you did not file appeal against the impugned judgment. Now the litigation must be given a full stop somewhere. Now you did not help yourself. Can you come and file an affidavit by taking leave of the court as that these are the things, my lord? And the apex court has said in a given case, if your statement comes to be not true, you will have to pay heavy compensation. In that background, my lord, I am taking your lordship to this judgment. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has prayed for directing the respondent authorities to award appropriate marks to the petitioner in accordance with OM dated 25/6/2012 in MPhil and teaching experience, and thereafter to appoint the petitioner in the post of assistant professor. The petitioner has projected that he is serving as assistant professor in the Karimganj College since 1/7/2005. And presently, he is the head of Department of Computer Science and Application under self-financing scheme in the said college. The petitioner had acquired PhD degree in computer science from Assam University, Silchar, and which was conferred in the 14th convocation held on so and so. In course of service on 19/12/2006, the petitioner got himself enrolled in MPhil degree course in Annamalai University under distance education mode after obtaining no objection certificate from his employer college. The petitioner was awarded his Master of Philosophy in Computer Science degree by the said Annamalai University in the examinations held on September 2008, and he was placed in first division. Pursuant to employment advertisement dated so and so issued by so and so, the petitioner had applied for selection and appointment to the post of assistant professor in the Pandit so and so Amjanga, Tulungia, Dalgaon. The learned senior counsel for the petitioner has submitted that though the petitioner appeared in the interview process held on different dates, but by granting lower marks by ignoring his entitlement, his candidature was rejected. The points raised by the learned senior counsel for the petitioner is discussed issue-wise. The issue raised are summarized as follows. Whether the petitioner was awarded lesser marks by not treating time spent for pursuing MPhil and PhD degree as teaching experience. B, whether the petitioner was illegally denied marks despite having MPhil degree. Whether the petitioner was awarded lesser marks by UF hostile discrimination on account of language. The learned senior counsel for the petitioner has submitted that at Dalgaon, the petitioner had given 8.0 marks less, and Tulungia he was given 1.03 marks less, which is in violation of OM dated so and so. It is also submitted that as per the petitioner's assessment, he was ideally entitled to 63.94 marks, amongst others, because the petitioner was entitled to 5 marks for teaching experience, 5 marks for his MPhil degree, and 5 marks for PhD degree. Your Lordship, kindly note this, 5 marks for PhD degree. This is not correct because, my Lord, I did not pray. I am not entitled to get. And my Lord, somehow, my Lord, your Lordship may ignore that. 5 marks for PhD degree because this is not in that OM also, your Lordship will not find that. The chart showing marks awarded, your Lordship, kindly see the chart. The first, in the next column, your Lordship will find regarding MPhil and teaching experience. Now, MPhil chart shows in Amjanga 5 marks, teaching experience in Tulungia 5 marks, in Dalgaon it is given 0. Then down below, your Lordship, kindly see teaching experience. In Amjanga given 5 marks, Tulungia given 5 marks, Dalgaon is given 2 marks. Now, to project entitlement of the petitioner to 5 marks for teaching experience, it is submitted that although under OM dated 25/6/2012, it was provided that the period of time taken to acquire MPhil and PhD degree shall not be considered as teaching research experience to be claimed for appointment to the position, but by communication under DO number dated 1/3/2016, the Secretary UGC had clarified that the period of active service spent on pursuing research degree, that is for acquiring PhD degree simultaneously without taking any kind of leave, may be counted as teaching experience for the purpose of direct recruitment, promotion to the post of associate professor and above. Accordingly, it is submitted that the MPhil degree being research-based, the same principle would apply there also. Par contra, the learned standing counsel for the Higher Secondary Education Department has countered the communication of the Secretary UGC dated 1/3/2016 by submitting that as per clause so and so of the University Grant Commission on minimum qualifications for appointment of teachers and other academic staff in universities and colleges and measures for the maintenance of standards in higher education regulation 2016, published in the official gazette by UGC notification dated so and so, it is provided that the period of time taken by candidates to acquire MPhil and PhD degree shall not be considered in teaching research experience to be claimed for appointment of teaching positions. In the office memorandum dated 25/6/2012, it has been mentioned in clause 7 thereto, the period of time taken by candidates to acquire MPhil and or PhD degree shall not be considered as teaching research experience to be claimed for appointment to the positions, clause 3.9.0. The learned standing counsel for the Higher Education Department has demonstrated that the reference regarding clause so and so as mentioned in clause 7 of the said OM dated 25/6/2012 is preferable to UGC regulations on minimum qualifications for appointment of teachers and other academic staff in universities and colleges and measures for the maintenance of standards. My lord, this part of my lord, the legal aspect, my lord, your lordship may not go, is not necessary in the sense because I am having sufficient year of experience, that is maximum 5. Therefore, whether I am entitled to get marks, my lord, there is somewhere it is given even 2008 regulation. If you continue research studies simultaneously along with your profession, my lord, you will be added marks there also. But I need not go to that extent unnecessary to confuse all these things. Because it is not necessary since I am having sufficient teaching experience.
After you got the MPhil.
After MPhil I obtained in 2008 until the date of my lord advertisement, I am having sufficient years of experience.
So there's no need to go to
So
that.
no need to go to that. It was my alternative submission and the Honorable Singhal Judge highlighted much on that without making any sort of, my lord, finding on my first submission. Now, therefore, my lord, I am skipping that. Then your lordship may come to page 176, paragraph 10. Thus, the point of determination number A is answered by holding that the respondent number 2 had not committed any illegality in refusing to consider marks to the petitioner by treating time span for pursuing MPhil and or PhD degree as teaching experience, notwithstanding that the petitioner might have actually rendered service to his college during that time. Now, my lord, what happened? Learned Singhal Judge ultimately remanded the matter, although I am having the valid PhD, MPhil degree. Now, the problem will be the moment you are sending it back there, now they will be influenced by paragraph 10. They have said, if you are having at the time of research, simultaneously you are doing your profession by without taking leave of your department, then you'll be not entitled to get marks there. Now, these may be confused by the authority as they have been doing all through. My lord, they will give me no marks in MPhil, no marks in teaching experience. That's the reason we are before your lord, my lord. Now, whether the non-acceptability of the MPhil degree of petitioner is illegally and whether lesser marks was awarded to the petitioner on amount of lack of proficiency in local language. The lordship may skip that because learned Singhal Judge has given finding in my favor. So that is not necessary to go into. Now, my lord, your lordship may come to page 178, para 14. It is seen that in his order dated 18/7/2008, the Director of Higher Education has admitted that there are 4 sanctioned posts of assistant professor in computer science in Dalgaon, and that advertisement had been issued for filling up of all the 4 posts. Accordingly, while the candidature of the petitioner was rejected, 4 candidates, namely Muhammad So-and-so, Sri Shubhmoy Dev, Sri Shubhrata Chetia, and Sri Bikram Patir were appointed. However, Sri Shubhmoy Dev had expressed his unwillingness to join, and therefore the other 3 candidates were appointed. The Director of Higher Education had again reiterated the observation made in the said authority's earlier order dated 24/1/2018 that as such, even if Sri Rajiv Das is given, Rajiv Das means suppleant, is given the marks for teaching experience and MPhil degree, then also he cannot be given the post as the college has very less enrollment. The court finds the reiteration of the said observation not only unjustified, but is again a blatant attempt to overreach the order dated 4/9/2017 passed by this court in WPC number so-and-so and order dated 16/3/2018 in WPC number so-and-so. In both the said orders, this court had emphasized that the director shall give a consideration as to whether the marks of having MPhil degree in the distant mode from the Annamalai University and the marks in the heading experience for having pursued PhD degree should be given to the petitioner. The considered opinion of the court as the Director of Higher Education Assam had admitted that 4 posts of assistant professors in computer science were advertised and was being otherwise filled up but for the refusal of one selected candidate to join, it is not open for the Director of Higher Education Assam to change the stand that because of fewer students, the petitioner cannot be appointed. It may be mentioned that the recruitment process was initiated by advertisement dated 8/5/2017, amongst others for selecting candidates for 4 posts of assistant professor in computer science in Dalgaon, issued by the Deputy Commissioner Darang. Mangaldi, a mention has been made regarding the communication dated 25/4/2017, issued by the Director of Higher Education. This would lead to a presumption that the Director of Education Assam has approved of the advertisement for 4 posts of assistant professor in computer science, selected and appointed 4 candidates to fill up all the said 4 posts, but when the said authority has found that it would have to consider the claim of the petitioner, the Director of Higher Education Assam has found a convenient escape route by manufacturing a plea that there are less students in the concerned college. Therefore, from the above, the indelible opinion of the court is that both the then directors of higher education had blatantly attempted to overreach the order dated so-and-so passed by this court in so-and-so and order dated so-and-so by a manufactured plea that there was less enrollment of students in Dalgaon. The said reasoning by the Director of Higher Education in the impugn order dated 18/7/2018 deserves to be and is accordingly rejected. The learned counsel for the petitioner has been able to demonstrate that Bengali is one of the state language of Assam. Moreover, it has been demonstrated that as per notification dated so-and-so, contained in the Handbook of General Circulars 1965, referred to herein before, the respondent authorities could not have discriminated the petitioner on account of his MIL in Bengali. Therefore, the rejection of the candidate of the petitioner on account of not having proficiency in local languages, which is mandatory as per the advertisement, is not sustainable in facts and in law. In this regard, the learned senior counsel of the petitioner had referred the general circulars. Now that circular is said, my lord, your lordship may skip that because this is not in question now. Now, page 181, paragraph 18, my lord. In the aforesaid context, the learned standing counsel for the higher education department had submitted that the advertisement contained such a clause, and therefore the petitioner, having participated in the selection process without challenging the advertisement, the petitioner cannot be permitted to challenge the selection process. In this regard, it is too well settled that a candidate, by agreeing to participate in the selection process, only accept the prescribed procedure and not the illegality in it. In this regard, my lord, this is in regard to that he has appeared in the selection process and therefore he cannot challenge subsequently. My lord, your lordship may skip that also. It's not at all relevant here. And your lordship may come to page 183, paragraph 19. Therefore, unless the respondent authorities demonstrate from any act, rules, notification, etc., that any local language has been prescribed for Dalgaon, the rejection of the candidature of the petitioner on the said ground is legally unacceptable in light of notification dated so-and-so contained in the Handbook of General Circulars 1965. Moreover, the learned senior counsel for the petitioner has successfully demonstrated that in the evaluation sheet which was provided to him through RTI, there is no such remarks by the panelist who had interacted with the petitioner and evaluated his merit. Therefore, the remark not having proficiency in local language, which is mandatory as per advertisement, which is contained in impugn order dated so-and-so by the Director of Higher Education, thereby disqualifying the petitioner, is held to be a manufactured ground and not existing in the record. It may be mentioned that as per RTI reply furnished, his candidature Amjanga was rejected for the reason not eligible for proficient in local language in respect of Tulungia. His candidature was rejected for the reason General MIL Bengali not so recommended. Therefore, the lack of proficiency of language being one of the reasons to deny appointment to the petitioner by the impugn order dated so-and-so is also rejected. From the impugn order dated 18/7/2018, it is evident that the Director of Higher Education Assam had failed to perform duty cast on him to scrupulously act as per direction contained in the order dated so and so, so and so. Then at page 184, paragraph 22. A specific direction was issued by this court by the order dated 16/3/2018 passed in so and so to consider whether the marks of MPhil and experience in PhD. Again, my lord, the lordship may see experience in teaching experience, not experience in PhD. Should be added, and accordingly, the order of 24/1/2018 by the Director of Elementary Education Assam was set aside, and the matter was again remanded back to the said authority to give an appropriate consideration as required by the order dated so and so. However, for the second time, the Director of Secondary Education Assam has failed to do so, as was directed by two successive orders passed in so and so, so and so, by ignoring that this court had also requested the Chief Secretary to the Government of Assam, the particular officer, namely B.L. Sharma, the then Director of Higher Education, be instructed in a proper manner that orders of this court are to be followed and not to be overreached and adjusted in a different manner. By further observing that if the orders of the court are not acceptable, it is open for the concerned person to file an appeal or a review in a prescribed manner. But an officer of the government cannot change the orders of the court even if the same are not agreeable. With such an observation, it was provided that the compliance of such action taken by the Chief Secretary shall be informed to the registry of this court. We are not informed as to whether the compliance was intimated to the registry. The Learned Standing Counsel for the Higher Education Department cited so and so, so and so. One wrong committed in one case cannot be allowed to repeat it in another case, as there is no concept of negative equality. My lord, this in some context he has said, my lord, your lordship, their argument was there that MPhil degree obtained through distance mode, that is off campus, is not acceptable. And my lord, I'll show your lordship from the record that more than hundreds of the assistant professors were appointed with the MPhil degree obtained through distance mode. Now they want to, my lord, persuade your lordship by saying that one wrong, it was a wrong committed. My lord, wrong maybe 1, 2, 3, not more than 100. Now these are the under that context this submission was made. My lord, I find this submission is what to be ignored, unnecessary spoiling of time, my lord. Now your lordship may ignore all that. Then my lord, paragraph 24, that also your lordship may ignore. Then at page 186, paragraph 25, my lord. Therefore, as the Director of Higher Education has failed to comply with the order dated 4/9/2017 passed by this court in WPC number so and so, order dated so and so, for which were inclined to hold that the MP order dated 16/3/2018 passed by the Director of Higher Education Assam is set aside. Now, my lord, here also there is some mistake committed. It should have been, my lord, order dated 18/7/2018. That order was set aside because if your lordship see the MP order number DHECECC 51, that relates to the order dated 18/7/2018. So, my lord, the MP order which was set aside is not 16/3/2018, but 18/7/2018. Your lordship kindly mark it. Otherwise, there will be again confusion. Now, for the reasons as discussed above, as regard the point of determination number B and C, the court is of the considered opinion that the competent authority in the higher education department should take a call. We refrain from deciding the matter as involves examining various notification and OMs of the higher education department of the state, University Grants Commission, Indira Gandhi National Open University and Distance Education Council, and therefore such an examination is left to the higher education department. Accordingly, we are inclined to remand the matter for fresh consideration by the authorities in the higher education department. As it is for the second consecutive time, the Director of Higher Education Assam has not complied with the order of this court. We are inclined to impose a cost of ₹25,000 on the higher education department, Government of Assam, to be paid to the petitioner as cost of the litigation, which shall be paid to the petitioner within a period of 1 month. and from the date of receipt of the certified copy of this order. The government in the higher education department will have the liberty to recover the said amount from the concerned officer posted as. Now, paragraph 28. As it is seen that the Director of Higher Education Assam has not complied with the requirement of order dated so and so, and has ventured on other relevant issues regarding less number of students, lack of proficiency in local language, which were otherwise irrelevant, not required to be gone into in light of the directions contained in the hearing before. Refer two orders of the court, thus we pass the following orders. The matter for a decision before the head of the department, secretary, higher education department, whatever designation held, as to whether the non-granting of marks to the petitioner for MPhil and experience in PhD, again, my lord, this is a wrong connotation, is the teaching experience for selection and appointment as assistant professor is liable to be interfered with. The said authority shall take note of the grievance of the petitioner that pursuant to employment advertisement dated so and so, issued with the respondent number so and so respectively, he had applied for selection and appointment to the post of assistant professor in Amjonga, Tulungia, and then Dalgaon. But he was not given marks for MPhil and experience in PhD. That should have been teaching experience, was not added. Resultantly, his candidature was rejected. Now, this paragraph is important. While examining the matter, it would be open to the said authority to examine whether the MPhil and PhD degree granted to the petitioner would entitle the petitioner any advantage in securing appointment to the post of assistant professor in computer science in the concerned college without commenting on validity or otherwise of the degree, as the validity of the degree is not under challenge. Now, that remain, my lord, is a closed chapter because nobody argued on that. And even, my lord, nobody filed an appeal in this particular issue. The said authority shall take note of the fact that in this order, we have already adjudicated and decided that the petitioner would not be entitled to marks for time taken by the petitioner to acquire his MPhil and PhD degree by considering it as teaching research experience to be claimed. Now, the head of the department, higher education department, within 30 days, my lord, they have been asked to do that. Then the last, in the event the authorities of the view that the selection and appointment of the petitioner is entitled to be approved, the said authority shall pass an appropriate order for approval and appointment of the petitioner if necessary by creating a supernumerary post with concurrence with other department like finance, etc., till the service of the petition is adjudicated. Now, this is all about the judgment. Now, my lord, your lordship may see what is the stand taken before the read court by the respondent number 2. Your lordship may kindly see at paragraph, page 129, my lord. Lordship may come to page 130, paragraph 6 onwards. That with paragraph 6, my lord, that with regard to the statements made in paragraph so and so, the deponent state that it is a matter of record and put to the writ petitioner to stricted proof thereof and denies everything which is beyond the records. It is stated that the writ petitioner has obtained MPhil degree on 29/9/2008 through distant mode from Annamalai University, Chennai, while he was serving as assistant professor in the Department of Computer Science and Application in Karimganj College. Further, as per Government of Office Memorandum dated 9/7/2012, it is clearly revealed that the writ petition is not eligible for getting marks for his MPhil degree. My lord, I will show this particular, my lord, OM that hasn't said that they are not entitled to get a marks. This is just a mere saying they have said. Since he acquired the said degree through distant mode and is against the decision of the government as well as notification made in the regard. Moreover, as per clause so and so, your lordship may skip that. Now, from this affidavit, your lordship will find, this is the only point they have taken, that notification dated 9/7/2012, there is a reflection that he is not entitled to get any marks because he acquired the MPhil degree through distant mode. That is the only, my lord, prayer in this particular affidavit. And another is, my lord, is not entitled to get marks if he is doing research studies simultaneously along with, my lord, professional work. Now, that is, my lord, I am speaking because I have sufficient experience. Now, in reply affidavit, your lordship will find, I'll read few paragraphs. Lordship may kindly come to page 134. This is affidavit by the appellant, my lord. Page 134, paragraph 5. That in regard to the statement made in paragraph 6 of the affidavit in opposition, your deponent states that statement is misleading and the deponent denies the same. Your deponent states that he, having obtained his MPhil degree from the Annamalai University through off-campus, that is distant mode, during the period when such degree was permissible, and therefore the said degree is required to be taken into consideration, and therefore he is eligible to get full marks on that. In the affidavit in opposition, it is also stated that the office memorandum dated 25/6/2012 issued by the Government of Assam Higher Secondary Department and clause 3.9.0 of UGC regulation stipulates that the said period of time taken by candidates to acquire MPhil, PhD degree shall not be considered as teaching experience to be claimed for appointment to the teaching position. But this is not applicable in the case of deponent because inasmuch as deponent was qualified as assistant professor having qualification MCA, MPhil during his period of PhD degree. Then, my lord, your lordship may see paragraph 6, my lord, in page 135, that in regard to the statement made that the deponent is not eligible for getting marks for his MPhil degree since he acquired the said degree through distant mode and is against the decision of the government is absolutely misleading statement and your deponent denies the same. In this regard, your deponent filed RTI to the Director of Higher Education Assam requesting to provide the list of in-service college regular teacher, assistant professor, librarian who have got NOC from Director of Higher Education Assam as well as governing body of the respective college for their higher education MPhil through distant mode, education mode, and subsequently became permanent and got promoted in acquiring the MPhil degree. Your deponent also requested to provide the list of teachers who have now, your lordship, in view of that, through RTI, my lord, they have submitted all the papers. Now I am taking to your lordship to those papers. Now, your lordship, before that, your lordship kindly see the office memorandum dated 9/7/2012, which is at page 141. Now, the stand of the, my lord, respondent number 7 is that if he obtain MPhil according to this office memorandum, he is not entitled to get any marks. I don't find any whisper of that in this office memorandum. The government of Assam is aware on the issue that off-campus center, study center, and the center operating through franchises are opened in the state by the universities outside the territorial jurisdiction of their universities. However, in view of the decision of the Honorable Supreme Court of India in Professor Yashpal versus so-and-so, off-campus centers beyond their territorial jurisdiction of the concerned university is specified. Recently, it has been noticed, reported that there are a large number of such off-campus centers of other Indian universities which are functioning in Assam. In spite of Honorable Supreme Court's judgment against such off-campus centers, study centers, in view of the aforesaid Honorable Court judgment and with a view that such off-campus centers which are existing are in violation of Supreme Court order, the following direction shall come into effect immediately. That concerned university shall ensure that no off-campus center, study center, and the centers operating through franchisee are opened by the university outside their specific territorial jurisdiction. Now, your lordship will find nowhere it has been said that if anybody is obtaining the MPhil degree, they will not be given any marks. Now, the stand in the affidavit is that. So that's the reason I'm showing it. Nowhere your lordship will find that. Now, your lordship kindly see how the government has acted. Your lordship may kindly come to page 143, my lord. This is through RTI, my lord. I requested the Deputy Director of Higher Education, that is MS Chinmay Talukdar. She has sent it to me, Mr. Rajiv Das. Undersigned hereby request the following particulars of information. Provide the list of in-service college sanctioned teachers, lecturers, assistant professors, librarian who have got no objection certificate, Assam for their higher education MPhil, through distance education, you lordship kindly see, through distance education mode, and subsequently become permanent and got promoted on acquiring the MPhil degree. Now, your lordship will find at page 146. This is from Principal Hemoprabha Barbora Girls College, Golaghat, Milord, to Mr. Rajiv Das. With reference to the subject cited above, I have the honor to say before you the following few lines. No objection certificate not available. Following assistant professor acquired MPhil through distance education mode. Mr. So-and-so. Then the following assistant professor acquired MPhil degree through distance education mode, subsequently became permanent in service. Now, your lordship will find number of professors, they got the MPhil degree through distance education mode. They not only, my lord, they have been made permanent. And now, so far, Mike is there grumbling. Now, your lordship may. Now, UGC has said, my lord, those persons who have got the degree on or before 10/7/2009. To that also I'll take your lordship. Now, these persons, your lordship will learn, some of them even after that date also got the degree. Even they were also accommodated. Then, my lord, then page 162, my lord. This is the Shivsagar College, my lord. They have obtained MPhil degree through distance mode. 10/11/2000. They are all in time, my lord. But I am showing that they have obtained the MPhil degree distance mode and they have been accommodated in service. Then page 163. This is from Shivsagar Girls College. Your lordship will find they are also. Now, in this, my lord, your lordship will find Mrs. Deepanjali Bhuiya. Degree obtained 21/1/2010 after the cutoff date. Cutoff date is, my lord, 10/7/2009. Even in that case also she was accommodated. Then page 164. We appointed 4 employees who obtained MPhil degree from distance mode during the stipulated period. List is in the page 165. They're from Vinayak Mission University, Madurai Kamraj University, PRA University, CNG. CNG University, my lord, your lordship is aware, the number one culprit, my lord, in the Shillong, the lordship is aware. My lord, they were giving, my lord, all false PhD degrees. My lord, these are the reason, my lord, Dr. Jaspal has said that this off-campus model will have to be stopped. Because even in a given time, it was found that just a small room like a pawn shop, they opened a university. And that is for purpose of selling the degrees. And the CNG was one of that. I think now it is closed down.
CM3.
CNG.
CM3.
CNG. Very Shillong.
Chandramohan.
Now, my lord, then page 167. 167, your lordship will find These are all from through distance, 2 or 3 persons from the regular mode, and all are from distance mode. My lord. And beyond the cutoff date also, the government has accommodated. Then page 168. This is from the same college where I am serving, my lord. Mr. Shamir from Shamiran Nath, Public Information Officer, Karimganj College. The lordship will find with reference to your letter cited above, I am furnishing here with the point-wise information to meet your requirement. One in-service teacher acquired his MPhil degree from distance education mode, Madurai Kamraj University. Now, Shakir Hussain Chaudhary, he was accommodated. He passed 15/4/2009 through distance mode. And then another person MPhil from distance education mode is Atul Kumar Paul through distance education mode from Vinayaka Mission University 2009. Manideepa Gop, she is also from Annamalai University, from same university where I obtained. Now, these are the instances, my lord, where your lordship will find there is no, my lord, quarrel on these issues. MPhil degree through distance mode, government has been recognized, they have recognized. My lord, the UGC has recognized, government of Assam has recognized, distance education, Delhi also recognized. Your lordship may find that at page, I will take your lordship to that page 105. Page 105 of my writ appeal, your lordship may see that. From the Public Information Officer, Annamalai University. Certain information from Annamalai University requested under the Right to Information Act. Your letter dated so and so. With reference to the letter cited, I am to inform you that the following details furnished below. The Annamalai University is recognized by the UGC and Distance Education Council, New Delhi. Annamalai University is one of the universities recognized by the University Grant Commission for the purposes of its grants. The degrees, diplomas awarded by the Annamalai University, which has been established by an act of the state, stand automatically recognized for purposes of employment under central state government as per letter dated so and so. So therefore, my lord, no quarrel for that it is not recognized. Now, my lord, I will take your lordship. UGC have filed one affidavit, my lord. In reply to that, your lordship will find my affidavit, which is at page 224. At 224, my lord. I'll read the affidavit, then I'll take to your lordship to decision of the appeals court. What is the stand of my learned friend to argue before your lordship? The counter affidavit filed by the respondent number 12, that is UGC, has no legal force in as much as before the read court, they did not contest the case at all, and the proceedings have attained final. There was no argument advanced on behalf of the counsel of respondent number 2, that is UGC, before the learned single judge standing counsel higher education addressed the honorable court. That your deponent state that while adjudicating the matter before the read court, respondent number 12 never challenged the validity of the MPhil degree awarded to the writ petitioner. The learned single judge very specifically in paragraph 28 of the judgment gave a finding to that effect. Therefore, when the question of validity of the MPhil degree has been adjudicated by learned single judge, as respondent number 12 never challenged the same, the matter attained finality. The respondent number 2 did not file any writ appeal also. When the proceeding has attained finality, parties are bound by the judgment and are stopped from questioning it. They cannot litigate again on the same cause of action, nor can they litigate any issue which was necessary for decision in the earlier litigation. These two aspects are cause of action estoppel and issue estoppel. These two terms are of common law origin. Their only remedy to approach the higher forum if available. The determination of the issue between the parties gives rise to, as noted above, an issue estoppel. That your deponent states one important consideration of public policy is that the decisions pronounced by courts of competent jurisdiction should be final unless they are assailed in higher forum. Furthermore, the attempt to re-argue the case, which has been finally decided by the court, is a clear abuse of the process of the court and contrary to justice and public policy. Filing of the counter affidavit by respondent number 2 to re-agitate the matter is an abuse of the process of the court, and the respondent number 12 liable to be imposed heavy cost, which may be assessed at ₹10 lakhs as held by the apex court. That in regard to the statement in paragraph 4 and 8 of the counter affidavit filed by the respondent number 12, your deponent states that University Grants Commission wrongly interpreted the reply of the director of Center for Distance and Online Education, Annamalai University. It is crystal clear from the annexure, respondent number 4 of the counter affidavit, the director rightly and briefly written that he joined and after attending the personal contact program, collected his transfer certificate and degree certificate from our university. From the above, it is crystal clear that the deponent was a student of MPhil in Computer Science, Director of District Education, Annamalai University. It is also to be stated that MPhil degree obtained on or before 10/7/2009 will act as a criteria for direct recruitment in colleges in Assam, irrespective of the mode of their degree, which may be on campus or off campus. That your deponent states that as per government OM dated 7/10/2009 and 1/11/2011, and as per minutes of the 42nd meeting of the UGC held on 27/9/2010, and through direct recruitment, more than hundreds of assistant professors are regularized from conditional appointment and recruited by the government of Assam. It is pertinent to mention, as stated in our affidavit reply against the affidavit opposition of respondent number 2, that one assistant professor along with MS Manideepa Gop, MPhil in Statistics from Annamalai University, from Department of Commerce, Karimganj College, and Mr. Deptush Chakravarti, MPhil in Statistics from Annamalai University, from Department of Statistics from SS College, Hailakandi, has been directly recruited by the DHE Assam as per the then norms of the government of Assam. That your deponent states MPhil degree obtained on or before 10 July 2009 will act as a criteria for direct recruitment in colleges of Assam, irrespective of the mode. It is further to be stated, all distance education programs are by default off campus in nature. Any student can learn, study from any location, even from home, through satellite channel, video, audio, etc., along with personal contact program. There was mandatory PCP which was held in the main campus and research work under guide on the main campus at least for 10 days. That your deponent states that he got himself admitted in MPhil degree distance education mode on 19/12/2006 from Annamalai University, already stated in paragraph 3 of the writ appeal. Your deponent further begs to state that Secretary to Government by letter dated 29/8/2006, page 104 of writ appeal, intimated that MPhil PhD courses should not be offered through distance education from academic year 2007-2008. My academic year was 2006-2000, prior to that, hello. So I was not affected by that. And they should be offered only in the regular stream. Your deponent's MPhil degree relates to the academic year 2006-2007, being enrollment number so and so. MPhil under distance education mode was well accepted by government of Assam up to the year 2012-2013, those who obtained MPhil degree on or before 10/7/2009. Your deponent states that government of Assam has recruited lecturer, assistant professor having MPhil degree in distance mode off campus from Annamalai University, Madurai, Kamraj University, Vinayak Mission University, Periyar University from 1st January 2006 to 31/12/2013. Some of them crossed their cutoff date 10/7/2009 also. It is pertinent to mention that government has already dispensed MPhil from 2007-2008 session by letter dated so and so. Therefore, there is no relevancy in highlighting letters dated so and so, so and so. Then your lordship may skip it. Then paragraph 9. That the deponent respectfully states that in reference to paragraph 9 of the reply, that now they have followed the referred one decision, division bench decision of this honorable court. That is Ashar and his case. My lord, it has got no relevancy so far this case is concerned. In that case, my lord, I'll read it, my lord, from here your lordship will get. The deponent respectfully states that in reference to paragraph 9 of the reply, that Ashar and his case is nowhere related to the instant case. In order to get marks in teaching experience, it is essential that the candidate concerned must have imparted actual total hours of teaching in the particular year with the standard of teaching hours of a regular assistant professor as per UGC guidelines. In order to qualify the requirement of standard of teaching hours, the person concerned must impart teaching for 40 hours a week as provided by clause 15.1 of the UGC regulation 2010. Other conditions as enumerated in junior research fellowship. In Ashar and his case, my lord, that was the candidate was junior research fellowship in science. And social studies stipulated that fellow with the consent of the guide may assist university in its academic works, etc., provided such work is not likely to hinder the research program on hand. The total amount of time spent on such activities should not exceed 10 hours a week. Now, if he's completed just 10 hours a week, obviously, my lord, this cannot be construed to be teaching experience. In order to get the marks as teaching experience, you must have 40 hours in a week, which this Ashar and his case, they did not have, and rightly that case was held. This has have got no relevancy so far these cases concerned. Now, my lord, your lordship, kindly see Annex 12 at page 232. There is the notification of the government of Assam.
Para?
232, my lord,
Yes.
Annex 12. In continuation of this department notification dated so and so, and in pursuance of UGC notification dated 1/6/2009, the governor of Assam is pleased to include the following conditions in toto for eligibility of lecturers required for the appointment and career advancement of teachers in the universities, government colleges, provincialized colleges of Assam as follows. As per provision of the University Grant Commission, minimum qualification required for the appointment and career advancement of teachers in universities and institutions affiliated to READ. Regulation 2000 were as follows. NET shall remain compulsory requirement for appointment to lecturers, even for those who with postgraduate degree. However, your lordship, this is important. The candidates having PhD degree in the concerned subjects are exempted from NET for PG level and UG level. Teaching the candidates having MPhil degree in the concerned subjects are exempted from NET. Now, if you are having MPhil degree, you are exempted to NET, and PhD also we are exempted to NET. Then that your lordship may see the next page 233. That is also by the government of Assam. In continuation of the department's notification dated 7/10/2009, and view of the University Grant Commission decision to exempt all candidates who obtained MPhil degree, PhD degree on or before 10th July, this is the cutoff date, my lord, 10 July 2009, from clearing NET to qualify for appointment as a teachers in colleges and universities by UGC Resolution 472 and meeting held on so and so. The Commission further resolved that since both the above mentioned regulations are prospective and not retrospective in nature, therefore, all candidates having MPhil degree on or before 10 July 2009 shall remain exempted from the requirement of NET for the purpose of appointment as lecturer, assistant professor. Now, further, all that your lordship may skip. Then the UGC, my lord, the next page 234. Minutes of the 42nd meeting of the University Grant Commission. Your lordship will find in the next page 235. In the middle part, the commission further resolved that since both the above mentioned regulations are prospective and not retrospective in nature, therefore all candidates having MPhil degree on or before 10 July 2009 shall remain exempted from the requirement of NET for the purpose of appointment of lecturer, assistant professor. Now, this, my lord, I am taking to your lordship because, my lord, last occasion, my learned friend argued that MPhil is not a required qualification for the purpose of assistant professor, which is negated by this document. MPhil is a proper, my lord, the UGC has said, the government of Assam has said so many times, and my lord, they have accommodated so many, my lord, lecturers. They have been confirmed in the service. Now, my lord, just to end my point of my submission, I want to buttress my submission by taking two of the decision of the Honorable Apex Court. It- Well, first, I am taking 99.5 SCC 590, paragraph 26 and 29. Para 26 and 29. It is settled law that the principle of estoppel and res judicata are based on public policy and justice. Doctrine of res judicata is often treated as a branch of the law of estoppel, though these two doctrines differ in some essential particulars. Rule of res judicata prevents the parties to a judicial determination from litigating the same question over again, even though the determination may even be demonstratively wrong. When the proceedings have attained finality, parties are bound by the judgment and are stopped from questioning it. They cannot litigate again on the same cause of action, nor can they litigate any issue which was necessary for decision in the earlier litigation. These two aspects are cause of action estoppel and issue estoppel. These two terms are of common law origin. Again, once an issue has been finally determined, parties cannot subsequently, in the same suit, advance arguments or adduce further evidence directed to showing that the issue was wrongly determined. Their only remedy is to approach the higher forum available. The higher forum was there, but they did not come. The determination of the issue between the parties gives rise to, as noted above, an issue estoppel. It operates in any subsequent proceeding in the same suit in which the issue had been determined. It also operates in subsequent suits between the same parties in which the same issue arises. Section 11 of the Code of Civil Procedure contains provision of res judicata, but these are not exhaustive of the general doctrine of res judicata. Legal principles of estoppel and res judicata are equally applicable in proceeding before administrative authorities as they are based on public policy and justice. Then I will take your lordships to paragraph 29. In Arnold versus National Westminster Bank, the House of Lords noticed the distinction between cause of action estoppel and issue estoppel. Cause of action estoppel arises where the cause of action in the latter proceeding is identical to that in the earlier proceeding. The latter having been between the same parties or their previous and having involved the same subject matter. In such a case, the bar is absolute in relation to all points decided, unless fraud or collusion is alleged, such as to justify setting aside the earlier judgment. The discovery of new factual matter which would not have been found out by reasonable diligence for use in the earlier proceeding does not, according to the law of England, prevent the latter from being reopened. issue staple may arise where a particular issue forming a necessary ingredients in a cause of action has been litigated and decided and in subsequent proceeding between the same parties involving a different cause of action to which the same issue is relevant. One of the parties seeks to reopen that issue. Here also, a bar is complete to re-litigation, but its operation can be thwarted under certain circumstances. The House then finally observed, but there is a room for the view that the underlying principle upon which staple is based, public policy and justice have greater force in cause of action. Staple, the subject matter of the proceeding being identical, they do not in issue step. Then your lordship can skip all that. Then your lordship may kindly come to 2011 3 SCC, page 408. I'll rely on paragraphs 12, 13, 19, 21, 23, 24, 25, and 39. Para 12, you will find at page 415. The principles of res judicata are of universal application as they are based on two age-old principles, namely interest, so and so, so and so. That is the state that there should be an end of litigation, another principle in nemo depo, so and so, meaning thereby that no one ought to be vexed twice in a litigation if it appears to the court that it is for one and the same cause. This doctrine of res judicata is common to all civilized system of jurisprudence to the extent that a judgment after a proper trial by a court of competent jurisdiction should be regarded as final and conclusive determination of the questions litigated and should forever set the controversy at rest. The principle of finality of litigation is based on high principle of public policy. In the absence of such a principle, great oppression might result under the color and pretense of law in as much as there will be no end of litigation and a rich and malicious litigant will succeed in infinitely vexing his opponent by repetitive suit and actions, exactly like the present case, my lord. The doctrine of res judicata has been evolved to prevent such an anarchy. That is why it is perceived that the plea of res judicata is not a technical doctrine, but a fundamental principle which sustains the rule of law in ensuring finality in litigation. This principle seeks to promote honesty and a fair determination of justice and to prevent abuse of the matter of accessing court for agitating on issues which have become final between the parties. Then your lordship may turn to paragraph 19. The constitution bench of this court in so and so, but the question as to whether a citizen should be allowed to challenge the validity of the same order by successive petitions under Article 226 cannot be answered merely in the light of the significance and importance of the citizens' fundamental rights. The general principle underlying the doctrine of res judicata is ultimately based on consideration of public policy. One important consideration of public policy is that the decision pronounced by courts of competent jurisdiction should be final unless they are modified or reversed by appellant authorities. And the other principle is that no one should be made to face the same kind of litigation twice over because such a process would be contrary to consideration of fair play and justice. Then paragraph 21. Following all these principles of constitution bench of this court in directed versus so and so, an adjudication is conclusive and final, not only as to the actual matter determined, but as to every other matter which the parties might and ought to have litigated and have decided as incidental or to essentially connected with subject matter of the litigation and every matter coming into the legitimate purview of the original action, both in respect to the matters of claim and defense. So the principle of constructive res judicata underlying explanation so and so of the CPC was applied to the case. We accordingly hold that the Reed case is a fit to be dismissed on the ground of res judicata. Then paragraph 23, my lord. Thus, the attempt to re-argue the case which has been finally decided by the court of last resort is a clear abuse of process of the court, regardless of the principles of res judicata that has been held by so and so. In paragraph 44, the report, this principle has been very lucidly discussed by this court and the relevant portion whereof are extracted below. One of the examples cited as an abuse of the process of the court is the re-litigation. It is an abuse of the process of the court and contrary to justice and public policy for a party to re-litigate as the same issue which has already been tried and decided earlier against him. The re-hesitation may or may not be barred as res judicata. In coming to the aforementioned finding, this court relied on Supreme Court practice so and so. Now you'll also may skip that. Now paragraph 25. On the premises aforesaid, it is clear that the attempt by the appellant to re-hesitate the same issue, which were considered by this court and were rejected expressly in the previous judgment, is a clear instance of abuse of the process of the court, apart from the fact that such issues are barred by principle of res judicata, constructive res judicata. Then, my lord, the last para 39. This court therefore dismisses this appeal with cost assessed at rupees 10 lakhs to be paid by the appellant in favor of so and so, so and so. That is all about it. Now, your lordship, kindly see, UGC respond number 12. They never contested. They remained a silent spectator in the courtroom. The court asked whether you want to say something. She remained silent. There was nothing on their behalf. Even they could have filed, if they were really hesitated, they could have filed a writ appeal. They did not. Now, at the fag end of the, my lord, here, when the argument was concluded, now they took a leave to file an affidavit. What, my lord, legal sanctity this affidavit is having? Now, my lord, my learned friend have to get through with this, my lord, principle of law, with the appeals court has decided. Then only your lordship can hear him. Otherwise, I don't think he has anything to argue. My lord, even in a recent case in the year 2023, my lord, the writ was filed. There was a delay of 8 years. Nonetheless, my lord, the writ court allowed it. Now the other side went in the filing SLP. Even in the SLP, my lord, in the memo of appeal, they did not say anything about delay. The Supreme Court has said no, since there was a question of delay, there is a substantial point, but it was never hesitated by you. So therefore, Supreme Court has dismissed the SLP, saying that at this stage you cannot do all these things. So here, these cases are better than that case, my lord. My lord, this is a 2023 10 SCC, page 634, paragraph 53, my lord. So therefore, by taking a cue from there also, my lord, I don't think they have any case so far respond number 12 is concerned.
2023 10 SEC.
Page 634, my lord. Your lordship may see to this paragraph 53, my lord.
You don't have an extra copy.
My lord, this is the only copy I have. Paragraph 53, my lord.
Right?
My lord, up till now this much, my lord, let my learned friend say, if anything necessary, I will reply.
May it please your lordship, my lord. Much emphasis has been given on the participation of the UGC by
You
filing
have
an
for respondent?
12, the UGC. By participation of the University Grants Commission in this appellate stage. Admittedly, my lord, we did not file any affidavit in writ appeal. My respectful submission, my lord, appeal is in the continuation of the original proceeding. Therefore, if this honorable court, this bench of this honorable court is pleased to allow me to file an affidavit, and my learned senior friend is agreed by that order, and he should have filed an SLP in this appeal or review of that order. Therefore, this issue has gone now. An appeal is a continuation of the original proceeding. Therefore, if this honorable court allows me to file an affidavit, then it is allowed. That issue, my lord, in my respectful submission, would not have been raised by a senior counsel that I cannot participate, I cannot argue. Whatever I am now, by filing this affidavit, is placing before your lordship is the law points. And I believe this affidavit will be of instrumental to decide the issues that raised before your lordship. The moot question that before your lordship is whether the MPhil degree obtained by this writ appellant petitioner is valid or not. Otherwise, the entire judgment in the single judge, passed by the honorable single judge, in his favor. There is no point of filing this appeal. The entire judgment in his favor. I don't know what for he is aggrieved. Now the question remains, he himself opened this Pandora's box. Now, if filing this appeal, this issues has cropped up whether the degree obtained by Mr. Rajiv Das through an off-campus mode. Admittedly, it was an off-campus study. Whether it is valid or not. My lord, without wasting a single minute, my lord, I may replace the judgment passed by the division bench of this court, my lord. In writ appeal number 55/2009, it was a common judgment passed in and 76 of the 2009. The coordinate bench of this honorable court in a division bench, my lord Justice Ajay Lamba and Soumitra Sakya, my lord, on 13/2020 has categorically held, my lord, that any degree through off-campus study center is invalid. The matter ends here, my lord. He took admission through an off-campus study center. This is admitted position. And he, maybe he has edited certain documents that he went there to examine to give the examination in this center. But his entry into the obtaining degree process is wrong, illegal. He cannot take admission in an off-campus center. My lord will kindly come to page 88 of the writ appeal. And the relevant portion is at page 89, the last paragraph. We have not raised any question as to the validity of the university.
Page.
Page 89, my lord, of the writ appeal. This is the RTI reply given to the writ appellant. Sri Rajiv Das. Annamala University is a valid university, it's a state university. There is no quarrel on this point. But they cannot provide degrees through off-campus mode out of the state. He took admission, kindly see the page 89 last line. The course of study is off-campus mode. So the university itself is saying, look, if it is an off-campus mode, there is no point of determining or adjudicating whether he went there for examination, whether he went there for personal contact program. It is all irrelevant. And kindly go through this judgment, if I may read, my lord, if lordship allows me. Small judgment, may I read the whole? Well, it's very precise. We need to know the actual backdrop of that particular case. My lord.
We'll take a break and come back.
My lord, as your lordship did. Sir, read from the beginning, my lord, paragraph 1.
Oh.
This judgment shall dispose of 2 writ appeals, intra-court appeals, one being writ appeal number so-and-so, titled Ashit Baran Paul versus State of Assam and 8 others, directed against the judgment dated so-and-so, rendered in writ petition number so-and-so, titled Geetasri Das versus State of Assam and another, and the other writ appeal number so-and-so, titled as so-and-so, rendered in writ petition number 298317, titled as Punendu Sekhar Devnath versus State of Assam. Both the writ petitions above mentioned were disposed of by common judgment dated 13/2019, which has been impugned in these 2 writ petitions. It is evident that the appellants were private respondents in the 2 writ petitions mentioned above. The issue that was brought up for adjudication before the writ court is that an advertisement was issued on 19/6/2016 for filling up post of principal of various higher secondary schools. In this selection, the appellant writ respondents were selected as first nominee and appointed as principal. It is the admitted case that appellant Sri Ashit Baran Paul had obtained MA degree from Agartala Center of Madurai Kamraj University. This is important. Madurai Kamraj University is in Chennai, and he obtained the degree from Agartala Center. It is also an admitted fact that the aforesaid degree obtained by the appellant is from an off-campus study center, Tripura State, situated outside the state of Tamil Nadu. Likewise, appellant Sri Bijannath was appointed as principal, however, had passed MA degree from Sam Higginbottom University Study Center at Silchar, Assam. However, the university for the said study center was located at Allahabad, Uttar Pradesh. The respondent writ petitioners raised a plea that a person who has obtained degree from a study center operating outside the state where university is located would not be a valid degree for the purpose of considering eligibility for the post of principal. Learned single judge, height, the judgment impugned held that the selection is liable to be interfered with on the ground that the incumbents, the appellants before us, do not possess a valid postgraduate degrees, which is an essential requirement under the rules. Consequently, their appointments as principal in the school is in question were set aside, and the respondents were given liberty to fill up the post from the panel of selected candidates in accordance with law. For considering whether a degree is recognized or not, it would be most appropriate to refer to the affidavit filed on behalf of the University Grants Commission. In both the petitions, the UGC brought out the facts and the legal position that UGC has never at any point of time granted the above named universities to open study centers outside the states where they were located. For the purpose of exact reference, we extract herein below paragraph 8 and 9 of the counter affidavit filed by Sri Amit Kumar Verma, holding the post of education officer in the UGC, Bahadur Shah Zafarmarg, New Delhi, on behalf of respondent number 8. The said paragraphs reads as under. that it is respectfully submitted that the basic issue that leading to the filing of the instant writ petition is that the master degree in economics obtained by the respondent number 4, Sri Asit Baran Paul, from the Madurai Kamraj University, Tamil Nadu, under distance mode from an off-campus center in Tripura is claimed to be invalid, thus cannot be used for any purpose. This honorable court at this juncture implicated the UGC as a party respondent and asked the UGC to clarify the aforesaid issue. The reply of the University Grants Commission in this point are as follows. Madurai Kamraj University, Madurai, Tamil Nadu is a state university, just like Annamalai University. It can operate within its state only. The university is not authorized to open study center, off-campus center beyond the territorial jurisdiction of the state. The University Grants Commission, after the judgment passed by the Honorable Supreme Court in Professor Yashpal case, reported in 2005, 5 SSC 420, has clarified the issue of territorial jurisdiction and opening of study center from time to time. However, it is on records that the University Grants Commission and erstwhile Distance Education Council under the IGNOU has time and again issued various notification direction in this regard. Be it stated herein that the UGC has never at any point of time granted permission to Madurai Kamraj University, Madurai, Tamil Nadu to open any study center, off-campus center outside the state of Tamil Nadu. Hence, it is categorically stated that the respondent number 4, who has obtained a degree through an off-campus center outside the state of Tamil Nadu, is not recognized by UGC. Moreover, Madurai Kamraj University cannot have examination center in Tripura or elsewhere except in Tamil Nadu. Therefore, appearing in the examination in Tripura, which was held by the said university, cannot be held good. That the answering respondent on behalf of the University Grants Commission begs to state that it is not the case that the University Grants Commission has issued only one directive, that is on 27/6/2013, or for that matter, notification, etc., as regards functioning of the universities which are imparting education in distance or open learning mode. It is most necessary at this point to make a mention of the notification issued from time to time in this regard. The UGC policies on territorial jurisdiction, study center, off-campus, etc., has been elaborated in various University Grants Commission's letters. The public notice dated 27/6/2013 was only reiteration of earlier policy of UGC on territorial jurisdiction of the universities. The UGC High Circular DO number so dated 9/8/2001 directed all universities as under. The universities can conduct courses through its own departments, its constituent college, or through its affiliated institution. There is, however, no provision for leaving it to private institution for conducting course leading to award of its degree. As per recent UGC guidelines, the universities are permitted to impart education and award its degrees through their own campus located elsewhere in the country or even at their own offshore campuses with the approval of the UGC. Looking into the widespread of franchising the university education through the private institution, the UGC has decided that any university which proposed to enter into collaboration with any private institution would be required to take prior approval of the UGC. The Commission has also decided that no university should be permitted to go for off-campus private educational franchise leading to the award of its degree. Accordingly, all the universities are being directed to stop franchising their degree education through private agencies, establishments with immediate effect. On similar line, reply was filed in the writ petition, which is subject matter of writ appeal number 55 of 2019. Considering the stand of the UGC to the effect that in terms of judgment rendered by the Honorable Supreme Court in Professor Yashpal, the issue of territorial jurisdiction and opening study center has been clarified by the UGC. UGC from time to time has issued various circulars and directions beginning 2001. The said UGC circular has been extracted in para 9 of the above extracted, which demonstrates that not only the appellants are not eligible to compete for the post of principal because they lack the basic qualification, not having passed MA, MSc from UGC recognized university, but also the said circulars and notification has been circulated repeatedly since 2001. It stands demonstrated that the appellants in the two appeals obtained degrees from study centers located outside the states where the concerned universities were located. Hence, the said degrees cannot be said to have been issued by UGC recognized university. Considering the state of the UGC as noticed above, we find no merit in these two appeals. The learned single judge has, for right reasons, held that the underlying essence and objective is to maintain a certain standard and level of teaching, examination and academic achievements of the student. A possible view has been taken by the learned single judge, which does not deserve any interference in this intra-court appellate jurisdiction. Accordingly, both the appeals are dismissed. Therefore, my lords, in clear terms, the coordinate bench of this honorable court has stated that if you have obtained any degree through off-campus study center or a franchising arrangement, this is not valid. Therefore, I request my lord not to go into the other aspects of the matter at the very threshold that he took admission and the university itself says that his whole study is through the off-campus mode. Number one. Number two, my lord, as ordered by this court, we made certain inquiries to the university concerns and asked them to produce certain documents. And they said we do not preserve any document. And we are on oath before this honorable court with their reply. Their reply, my lord, in the queries made by this honorable court, paragraph annexer 4, R4, 210, page 210. I don't know this page 210 is there or not. My affidavit, my lord, that paragraph 8 I have extended. I just like to. My affidavit starts at page 199. Affidavit filed by MS Neera Chopra for University Grants Commission. Respondent number 12. Has your lordship got?
Yes.
Kindly come to page paragraph 8. Next page and then next page.
Para?
8. That this honorable court height order dated 4/12/2023 directed the UGC to clarify as to whether the MPhil degree obtained by the writ appellant Sri Rajiv Das from Annamalai University is valid or not. To comply with the said direction of this honorable court, the competent officer of the UGC had communicated with the registrar of the Annamalai University and put necessary petitioners to obtain information as to whether the said degree obtained by the appellant was obtained through off-campus study center or from the main campus of the said university. But the said university did not answer the queries raised by the UGC and instead sent a very vague reply. The said university astonishingly informed the UGC that they have not kept any data as regards the queries raised by the UGC since those were 15 years old. The UGC in its appropriate administrative level has taken this matter seriously and would propose to take appropriate action against the said university following a further inquiry. Since this affidavit is filed to address this particular issue, the UGC right now not in a position to file a detailed affidavit. However, the UGC deems it appropriate to point out some documents annexed along with the writ petition, which are conclusive proof of the fact that the appellant took the degree not only through distance mode, but also from an off-campus study center. First of all, page 33, annexer 4 of the writ petition. This is a letter of the principal Karimganj College dated so, whereby he was given permission to pursue MPhil degree without hampering the classes of the college. Secondly, page 31 and 32 of the 32 annexer 3 of the writ petition shows that he appeared in the final exam of MPhil degree in the month of September 2008. That apart, it is not known to anyone what the course duration was and when did he took admission. Thirdly, page 65, annexer 15, it is not 65, annexer 15, a RTI reply, just now I have shown to your lordship, given by the Annamalai University the petitioner clearly says that he took degree through off-campus mode. The degree obtained by the writ petitioner appellant through distance mode is not a valid degree if it was a degree offered through an off-campus mode under the guise of distance education mode. The Joint Committee of UGC AICT DEC, by its letter dated 13/5/2003, is annexes R1, directed to all vice chancellor, head of institution to limit the distance education program of the institution to the neighborhood of the location of the main campus or at most within the state. The Honorable Supreme Court in the case of Hyde's judgment dated 11/2/2005 in the case of Professor Yaspal and another held that in view of Article 245(1) of the Constitution, Parliament alone is competent to make laws for the whole or any part of the territory of India, and the legislature of the state may make laws for the whole or any part of the state. Therefore, my lord, the regulation issued by the UGC in maintaining the standards of higher education in India, being the subject matter of Central Union List, entry 66. And the education is a subject matter of concurrent list, entry 25. But maintenance of standard of higher education in India is a subject matter of Union List, entry 66. Therefore, whatever the regulation issued by the University Grants Commission being the statutory body of the country in maintaining the standards of higher education in conformation with the central government of India is to be held afield. White letter dated 16/4/2009 addressed to the state government, it was requested to make immediate action to take suitable steps for amending the existing acts made so as to bring the same in conformity with the observation made by the Honorable Supreme Court to stop all the state private universities in the state from operating beyond the territorial jurisdiction of their state in any manner. White letter dated 15/6/2009 addressed to the Vice Chancellor of the State University, it was requested to ensure that no off-campus centers, study center, affiliating college, and the centers operating through franchises is opened by the university outside the territorial jurisdiction of the state in view of the judgment of the Honorable Supreme Court. That another question that was decided, as my learned senior friend has said that Asarani Brahma judgment has no relevance in this case. I also agree with him because he is not claiming marks for the PhD for the period when he was taking the PhD degree. So I'm leaving it. He abandoned this claim. Now that given the above, the UGC is of an unhesitant view that the writ petitioner shall not get the benefit of his MPhil degree if he cannot prove the fact by adducing admissible evidence that he took admission in the course in the main campus of the university, going through its admission process. So I will not go for the other 2 points that UGC is emphasizing. He has to prove that he took admission there.
Where's your annexure R1?
R1 is not very legible below. Not very legible one. I would provide a typed copy of this, Miller. Not today, right now, Miller. These are the late notifications that there was a claim, Miller, that UGCS for the first time in 2013 said that there will be no off-campus center.
You're basing your argument on R1,
Well,
annexure R1,
well,
and you filed a totally illegal.
I'll give you.
My lord, I could not get anything. It is not readable at all.
No. They are-
How the registry is passing it, I wonder.
I don't know.
Well, I'll give you right type copy. Miller. Actually, you skip my mind. Skip my notice. Last paragraph is, this is important, Miller. The UGC has already issued circular advising all the universities to desist from the pressure of granting, desist from the practice of granting franchising. As first step, we have decided to impress upon you the necessity to limit the system of program delivery by distance education of your institution to the neighborhood of the location of your main campus or at the most within the state. This is the relevant portion of the. Now, this is an advisory from the UGC in 2003 that the distance education program should not go beyond the state of the university.
Yours is legible.
Well, I'll give a type copy, my lord. I'll give a type copy. But during the course of the day, I'll give it. For reference to lordship, if would like to refer to this, my lord. Actually, photocopy tarpora scan kori pothai to. So they send this document by scanning for email. So printouts of this Sometimes it does not come good.
We'll have to read it. It's done like this.
At least you could have put in a typed copy.
Yes, I'll give it, Milan. I'll give me some time. I'll give it a
I
type.
don't know how the registry accepted this affidavit.
Then, my lord, the specific queries made by the UGC to the Annamalai University as regard the appellant, my lord, appellant's MPhil degree at page 210, annexure R4, my lord. This is important, my lord.
210.
The queries were, my lord, credential of the candidate enrolled and details of the program. Details of the center at which the candidate is enrolled, attended PCP classes and attended the examinations. Attendance certificate. Details regarding PCP classes and attendance of the same. Degree certificate awarded by the university. Now reply is, my lord, a conjoined reply has been given. He joined and after attending the personal contact program collected his TC and degree certificate from our university. Since these records are related, date back 15 years, we no longer retain the physical records related to this issue. The information provided is sourced from our reliable data storage. This is the reply. His own university does not support him. Just they said he joined. How he joined? On one hand, the Annamalai University through RTI reply has categorically stated that his degree course was off campus mode. If it is off campus, matter ends. This honorable court, the coordinate bench of this honorable court has held that if you have got any degree through off campus mode, it is illegal, invalid. Had it been proved, had it been supplemented otherwise by the university on the queries made by the UGC, then, my lord, this judgment of Asit Baran Paul that I have just read out, the judgment would not have come into play. But they have not supported our queries. We have taken this issue to a different level for making an inquiry by the UGC. It is a different thing. But how can the university say that 15 years records are not there? University cannot throw out any record. Educational records cannot be thrown out. So, my lord, my only question is, so far as UGC is concerned, that no one should get a benefit of an invalid degree. Because selling of degrees, selling of PhD degrees, or for that matter, MPhil degree. And one more thing, my learned senior friend has stated, referred to in his reply to my affidavit, referred to a UGC resolution on 473 meeting. That, my lord, I'm sorry to say that resolution of the UGC was not approved by the central government. And this has been upheld by the Supreme Court in P. Susila judgment.
Where is that?
Judgment.
Is there in the record? P. Susila judgment is in the record.
No. The meeting minutes.
It is in page 233.
My notes, this is my note is at page 234. The resolution that one who has got MPhil and PhD degree may be exempted from NET was not accepted by the government of India. And in this aspect, in this issue, there is a judgment passed by the Honorable Supreme Court, the P. Susila, reporting to KS. And that judgment of the Honorable Supreme Court upheld the decision of the central government. That the ratio of that P. Susila judgment is, my lord, that UGC cannot do anything which is beyond the scheme of the central government. It is a scheme of the central government that NET is compulsory. NET shall remain compulsory, but if somebody takes a PhD degree in accordance with the 2009 regulation of the PhD degree, then he may be exempted. This has been a clear and all along stand of the central government and the UGC. MPhil has never been a required qualification, madam. MPhil has never been a required complete qualification. One who has got MPhil degree, nothing to do with the required qualification for the post of assistant professor. Nothing, nowhere at any point of time. He got some marks in the university during the interview process is a different thing, but that has not been a criteria for sorting as his name for the post of assistant professor. And this 472 meeting held on 27 September 2010 was not accepted by the central government, and hence Supreme Court held that if it is not accepted by the Supreme Court, then UGC cannot do it, because UGC has to act in accordance with the policy laid down by the central government. This is the ratio laid down in that PCC letter. But there is nothing much to say. Lordship will look into the records and say, will definitely examine the issue that though he in his reply affidavit, he has annexed certain documents showing that his administration, he went to the personal program, CPC, personal contact program, and he entered examination in the university campus. Makes no sense if his admission, if his course is according to the university, is through the off-campus. The remaining things makes no sense. And this issue has been decided by this court. I rest my argument.
But I will reply what my learned friend has said. No, nothing so.
Yeah.
Now, he has referred one judgment, my lord, saying that in Tripura, the examination took place. In this case, my lord, what happened? The examination center, your lordship will find, the document is there. My learned friend has saying orally many things. You must say in your affidavit so that I can reply accordingly. You are half-heartedly, you are saying 50% from here, 50% orally. There is no chance to give me a chance to say what he's saying. Now, your lordship kindly see at page 19 of my page 240, my lord. Your lordship kindly see where the examination center was, that is in Annamalai Nagar. They never replied all these things. Page 240. Last year, lordship will find Annamalai Nagar. And the division bench judgment which he referred, that is in relating to that MA degree he took, the examination center was at Tripura. So there is a world of difference between the two. Now, your lordship kindly see other papers. MPhil is a degree of 1 year, my lord. And he at page 236, your lordship kindly see. He got admission in the academic year 2006-2007. Then page 237, attendance certificate in the campus from 4/4/2007 to 8/4/2007. Optional was graphics and computer vision. Then your lordship will find Annamalai University at page 238. The examination center, Annamalai Nagar, Coimbatore, Chennai, Madurai, Salem. So these are the examination center. My examination center was number 1, Annamalai Nagar. Then page 39 certificate. The dissertation video classification using spatio-temporal features is recorded of research work done by Rajiv Das. They never denied all these things. Page 240, this examination center, Annamalai Nagar. Then the result sheet, your lordship will find 241, 242. These are all on record, my lord. They never say these are all fraudulent document. And by citing a decision saying that degree was obtained in Tripura. So therefore it is in fact situation of that case, it may be okay. But how you are relating with this case? Where is the pleading? There is no pleading to that extent. Again, my lord, the government has recognized that your lordship has seen already at page 233 to 232. 233, the government has recognized that MPhil degree. And in view of that, my lord, more than 100 of assistant professors have been recruited and they have been, my lord, in only their standard of education, they are finding fault in my case only. And the rest of others, they are not saying anything. Even beyond the cutoff date, 10/7/2009, after that also they obtained degree and they have been recruited in a permanent basis. And orally they are saying all these things. Is there any pleading, whatever is stated? So therefore, your lordship kindly scrutinize the matters in view of the documents furnished by us.
Well, so far as my senior friend has said that there are some documents to show that where his examination center was and where he attended the personal contact program. But we do not have any apparatus to verify these documents, the validity of these documents, because of the fact that university itself says they have not kept any records. Therefore, my respectful submission, my lord, these are disputed questions. Disputed questions.
Not so far record keeping are concerned, your lordship knows that some of the departments keeping documents for 5 years, some 10 years, some 15 years. So this is 15 years back documents. Let them show that they will have to keep mandatorily for 15 years those documents. Now, my lord, you did not contest anything, you don't file appeal. At the time of hearing, you are not saying anything in the affidavit and you are arguing everything. That's the thing happening here, my lord. My lord, I leave up to your lordship how the UGC is dealing. This should be taken to task, my lord. There is another, my lord, Delhi High Court judgment recently it has come. If you make a false statement before the court, my lord, you can be booked under section 279 of IPC. I'll go to that extent also, my lord. I'll face that judgment, my lord. If it is concluded today, I'll face the judgment before lord. You know, I think the time has come to go to that extent also. So what is that interest you have? You are not divulging everything before the court rightly, and we are arguing. There is no pleading, but then arguing. There is limit of everything, mate.
Wait, please, your lordship.
You have for respondent?
Respondent lordship 1 and 2. I have already concluded my argument, lordship. Probably my lordship looked at it, lordship. Just,
You can reiterate.
just, just I can point out two things, lordship. Regarding off-campus, lordship, page 88, lordship. Kindly come to page 88, lordship. Page 88, lordship. It's a document issued by the Annamalai University, lordship, in respect of information sought by the petitioner, lordship, where it says that, lordship, my lord may kindly turn to page 89, lordship. Last line, 89, lordship. The course of study is off-campus mode, lordship. It's a document of the Public Information Officer of the Annamalai University, lordship, and which is annexed here by the petitioner himself, lordship. The document itself reflected that the courses offered is off-campus mode. If it is off-campus mode, then lordship, it is lordship covered by the our High Court Division Bench judgment, lordship, Osit Burn Pal, lordship. It is not a disputed fact that when petitioner himself annexed here it, and I am relying that particular document as because it's a public document, it's obtained through the RTI information, lordship. And it says that it's a off-campus mode. If it is off-campus mode, then it is lawsuit covered by our division bench judgment, as well as the judgment delivered by the Honorable APS Court in way back 2005, Professor Yespal. That was also I relied in other day, and Kumansol Institute of Technology also. Just type 11 paragraph I have pointed out. Go.
Just us.
Lordship.
For all of you, these issues,
Lordship.
validity or otherwise of the documents,
Lordship.
appeal degree,
Lordship.
was not the issue before the learned single judge.
Lordship, it is not before it. So Lordship may kindly come to pay judgment of the learned single judge, Lordship.
Yes.
Learned single judge, Lordship. Learned single judge page 188, Lordship.
180.
188, it is kept open, Lordship. My lord may kindly come to page 188C, Lordship. This is the observation of the learned single judge, Lordship. It says that, Lordship, while examining the matter, it would be open to the said authority. Said authority is the director, Lordship, to examine whether the MPhil and PhD degree granted to the petitioner would entitle the petitioners any advantage in securing appointment to the post of assistant professor in computer science in the concerned colleges, Lordship. It's a one part. First part, Honorable Court says that, Lordship, it is open for the state, open for the authority, for director. Then Lordship may come to next part, Lordship.
No, read, huh?
Next part says that without commenting on validity or otherwise of the degree, as the validity of degree is not under challenge in questions, Lordship.
Yes.
So it was not in question.
Lordship, we are not challenging, Lordship. Validity part challenge,
No, that was not questioned by you also.
Lordship, but otherwise,
Forget challenging it.
otherwise, Honorable Court kept it open, Lordship, to consider whether that marks is he entitled or not, Lordship. Honorable Court says that Honorable Court did not comment on regarding validity of the MPhil degree, as it was not a question before the Honorable Single Judge. But Honorable Court also says that, Lordship, it is the authority to examine whether he is entitled the marks on the basis of MPhil degree or not, Lordship. This is the observation of the Honorable APS Court. In my understanding, Lordship, this is the observation. Honorable Court says that it is open for the authority to examine whether he is entitled the marks on the basis of the degree for the, in respect of the MPhil degree.
Yes, there is one thing.
One thing, and Honorable Court also says that Honorable Court did not comment regarding the validity and otherwise, Lordship, as because that point was not raised before the Honorable Single Judge, Lordship.
That's what we are trying to tell you.
Honorable Single Judge did not say that you cannot open it. Honorable Single Judge says that it is the authority who can examine it, Lordship. My Honor, again kindly peruse the paragraph. My Lord, may kindly peruse again this. While examining the matter, it would be open to the said authority to examine whether MPhil and PhD degree granted to the petitioner would entitle the petitioner any advantage in securing appointment to the post of assistant professor in computer science in concerned colleges, Lordship, without commenting on validity or otherwise of the degree, as the validity of the degree is not under challenge in questions, Lordship. Honorable Court says that, Lordship, Honorable Court regarding validity part, Honorable Court did not determine it, as because there is no any questions, no any issue raised before the Honorable Single Judge that whether his degree is valid or not. Otherwise, Honorable Court left it open to the authority to examine whether he is entitled the marks or not, Lordship.
We don't think so.
This is the in my understanding, this is the observation of the Honorable Court. This is the observation of the Honorable Court, Lordship.
Read a prayer to somebody.
This is the Honorable Court said, again, my Lord may read. While examining the matter, it would be open to the said authority to examine whether the MPhil and PhD degree granted to the petitioner would entitle the petitioner any advantage in securing appointment to the post of assistant professor in computer science in the concerned colleges, Lordship. Without commenting on validity or otherwise of the degree, as the validity of the degree is not under challenge in question, Lordship. Today also, we are not regarding validity of the degree, Lordship. Whether he is entitled the marks or not, Lordship.
That's what we want to know.
Right. My lord, if the entitlement is concerned, then my lord, the valid degree, he has to, the condition precedent is that he has to have a valid degree first. Then the entitlement will come into later. And thereafter also, my lord, will see
No,
the,
but that was not a question raised before the writ court.
so my lord, kindly see their prayer in the writ appeal.
Even also, Lordship, Honorable Court did not bar us, Lordship. Whether single judge, Honorable single judge says that you cannot open it. Whether single judge says that here, Lordship, you cannot examine it, Lordship. It is not the language of the Honorable single judge. Honorable single judge says that it is open to, it would be open to the authority.
Open to the authority first part.
Open to the
They're
authority,
having a MPhil or PhD degree
Lordship.
would entitle the petitioner to have some advantage.
Advantage, Lordship.
So,
That
this
is,
is in the context of allotment of the marks
Lordship.
as per your own notifications,
I will come it. Lordship.
2012.
Whether with 12, I'll just clarify. Within a 5 minutes, I'll
And,
clarify.
and the validity of or otherwise of the degree was.
Validity or
has not been
otherwise degree
challenged
was
by
not a-
anybody,
Not a question before the
Because of-
Honorable single judge
kept open.
kept open,
Right.
Lordship.
It was not kept open.
It was.
They refused to, the single judge did not decide the comment on the merit
Single
because
judge,
this was not under challenge.
single judge did not decide the issue, whether it is a valid degree or not. But single judge kept it open regarding consideration of that MPhil degree.
No,
whether
that
For awarding marks.
that is where having a disagreement with you.
again, I am reiterated, Lordship.
There is two part.
There is
First part is the petitioner having the degree of MPhil or PhD, whether it is entitled,
Lordship,
it is in connection with the allotment of marks,
Lordship,
right?
Lordship,
Second thing, nobody has challenged the validity of the degree.
Lordship.
The single judge has refused
There is
to
no dispute, Lordship.
comment on the issue.
There is no dispute, Lordship.
Two parts.
Two parts regarding, I am relying first part, Lordship. Second part also, there is no dispute. There is no any silence regarding validity. First part says that regarding advantage, it is open to the authority. What is the advantage here, Lordship?
Marks.
Advantage is only marks, Lordship. Whether he is entitled the marks, 5 marks for MPhil or not. This is only the advantage. Nothing is there, Lordship.
Your case is that is it your case that since the MPhil degree cannot be recognized or it is invalid,
MPhil degree
cannot
is,
be considered valid degree, therefore he is not entitled.
MPhil degree
Is
is
it your
a,
case?
MPhil degree is a off
Just
campus.
listen.
MPhil,
Is it your case that since the MPhil degree is not valid, it is not it cannot be recognized, therefore he is not entitled for 5 marks for MPhil degree? Is it your case?
regarding validity part, we are not the authority, Lordship.
Yes.
The higher education department knows the authority. We can only see the documents under what modes and how they have obtained the degree.
Yes.
If the degree is not permitted in
So, is it
conformity,
your case?
our case is that, Lordship.
Not giving a marks, awarding marks to the petitioner is on the basis on the ground that the degree obtained, MPhil
It
degree
is a
obtained by the
off-campus mode, Lordship.
off-campus.
It is a
Is it your
off-campus.
case?
Yes, this is our
Is it
case.
your pleaded case?
This is our case, Lordship.
Is it your pleaded case?
It is our case, Lordship.
Where it is?
It is our case,
So,
Lordship. It is
so-
our case, Lordship.
You have to read it with B and C together.
Lordship, Lordship. The said authority shall take note of the grievance of the petitioner that pursuant to the employment advertisement dated so and so issued by the respondent of 4, 5, and 6 respectively, he had applied for selection and appointment of the post of assistant professor on so and so. But he has not given marks for MPhil experience. MPhil and experience of PhD was not added, and resultantly his candidature was rejected, Lordship.
Sen-
Now second part, Lordship.
Second part.
Second part is says that while examining the matter, it would be open to the said authority to examine whether the MPhil and PhD degree granted to the petitioner entitled the petitioner any advantage of securing appointment to the post of assistant professor.
That's what.
That is the finding of Honorable Single Judge. Single Judge says that first part B says that he is not allowed the marks of the MPhil, and second says that he is not entitled the marks for the obtaining the
See,
PhD degree.
one part is he was not given marks for MPhil
MPhil.
and experience in PhD.
Experience in PhD
But
was
that
not
is,
given.
that is not correct. It is to be teaching experience.
Lordship.
All right, whichever, whichever.
In
Now,
teaching-
thereafter, he said,
in-
while examining that matter,
Lord,
while
while-
examining that matter,
Hmm.
you will have to see whether the MPhil and PhD degree granted the petitioner would entitle the petitioner to any marks.
Lordship, that is the issue, Lordship. Now, Lordship, we have to examine. We have to examine, Lordship, whether it's entitled or not. Even today, on the basis of that judgment, this is a premature appeal, Lordship. As because, Lordship, till today, no decision was taken by the authority, whether it's entitled or not.
What is-
Otherwise, also, this is my only submission.
What do you mean by premature appeal?
As because, Lordship, regarding paragraph C, no decision was taken till today, Lordship. Paragraph C,
Only
Lordship.
if you take it after your decision, only appeal will lie, according to you.
I am not saying that, Lordship. If Lordship has pointed out that the B is consonantly reading with the homogeneously in the C, Lordship. C also says that C is not an independent, Lordship. B is also not an independent. B says that his marks was not given in respect of MPhil. C says that, also B says that the experience marks in the PhD was not given to that. Then, Lordship, C says that while examining the merit, it would be open to the said authority to examine whether the MPhil and PhD degree granted to the petitioner would entitle the petitioner any advantage in securing appointment to the post of assistant professor in computer science in the concerned colleges, Lordship. It not says that Honorable Single Judge never says that you cannot examine. You have to give the marks. It is not the language of the Honorable Single Judge.
Can you show us that the petitioner was not allotted the marks for appeal?
Lordship.
On what ground?
Lordship,
Any
as,
documents, any pleadings by you?
as per our documents, Lordship, it's a distance vote, Lordship.
Where it is?
It is.
Have you stated that in your affidavit?
Lordship, it is there in our affidavit, Lordship. Says affidavit, Lordship. Paragraph 6, Lordship.
Para 6 page
130.
130.
130.
Right.
130. Put 130. Affidavit starts from, Lordship, and are to page 129.
Yes.
Paragraph 6, Lordship. With regard to the statement made in paragraph so and so, the deponent states that it is a matter of record and put to the lead petitioner state proof thereof and denies everything which is beyond the records. It is stated that the lead petitioner obtained MPhil degree on so and so through distance mode from Annamala University, Chennai, while he was serving as assistant professor in the Department of Computer Science and Application in Karimganj College, Karimganj. Further, as per OM dated so and so, it is clearly reveals that lead petitioner is not eligible for getting the marks of MPhil degree, since he is acquired the said degree through distance mode and is against the decision of the government as well as the notification made by in this regard, Lordship. Moreover, as per UGC's clause so and so, the teachers and academic staff of universities and amendment rules 2016 also says that laws, that part. It's our stand is that it's a distance mode, Lordship, so we are not giving the marks, Lordship. Otherwise, also, Lordship, page 88 also, Lordship. Page 89, it says that's a off-campus mode. It's a RTI reply.
That we have seen.
And again, my lord, may kindly come to the pair of the read petition, read appeal, Lordship. Read appeal. Page 21, Lordship. 21, yes, sir. 21. 21. What is the pair of the read appellant, Lordship? In the premises approach, your appellant says that your Lordship may be pleased to call for the records, admit the appeal, issue notice to the respondent to show cause as to why the part of the judgment dated so and so, that is respondent number 2, had not committed any illegality in refusing to consider the marks to the appellant by counting time spent for pursuing MPhil and PhD degree in teaching experience, notwithstanding that the appellant might have actually rendered service to his colleges during the time should not be set aside and quashed. What is the pair? This is the pair of the petitioner, Lordship. And this is read appellant. And this pair was already lordship settled by the Honorable our High Court Division Bench in Asarani Bombas case. He is not entitled the marks for the PhD and MPhil lordship. Time is spent during the PhD and MPhil. And he himself says that lordship. Notwithstanding that the appellant might have actually rendered service to his college during that period. He himself admitted that in the pair portion itself says that in that particular period he is in the service lordship.
Otherwise, he is eligible.
Otherwise, he is eligible. He is
Or an
PhD
MP or
degree.
PhD.
He has a
Yes,
PhD.
he has a PhD degree. He is eligible. Regarding eligibility part, we have no issue, lordship. Only awarding for marks, he has the PhD. And regarding MPhil lordship, MPhil since 1978 lordship. Ministry of Human Resource Department 1976, they had a notification. At that point of time, lordship, net and slate is a compulsory requirement, lordship.
Okay.
1978 to till today, nowhere university grants commissions the regulatory authority as well as Ministry of Human Resource declared MPhil as a required qualification for the post of assistant professor, lordship.
Any point of time.
No point of time, lordship, till today. Even lordship, the annexure which is made, just now I am clarified it also, lordship.
Where is the pleading value? There is no pleading.
Not required, not required. It is a settled proposition, or it is not a disputed question of fact. The higher education, as per NT 66, is a subject of the central government, and we are bound by the prescribed UGC minimum required qualification. We cannot dilute it. We cannot dilute it. We never dilute it. Lordship, lordship.
It was issued somewhere in 2018 or 19.
One is 2011 lordship, 2011 one notification issued, 2017 notification says that lordship, as because lordship the central government UGC has not implemented it, so that was not,
So that will be effect from the date of notification.
but lordship,
Suppose
lordship, lordship,
if you issue a notification,
lordship,
which you have allowed the MP
lordship,
degree holder
lordship,
to participate in the exam
lordship,
for assistant
Lordship.
professor. Then now you issued a notification on the basis of the UGC
Lordship.
regulations
lordship,
that everyone should have that candidates must have a
lordship,
net slate.
lordship,
There's no exemption for MP
lordship,
degree holder.
lordship,
That notification comes into effect prospectively.
lordship.
It said it will come into effect from the date of notification.
Lord.
That means prospective. So how do you do the selection process where you have exempted the net and slate? You cannot have a retrospective effect.
Even lordship, we cannot exempt lordship. We cannot exempt lordship. We cannot exempt
But
notification,
what about those
even-
assistant professors
even lord,
whom you have allowed?
even lordship, we cannot exempt. As because lordship, my lord, I have already supplied a copy of the lordship central government letter that is in the record lordship 2010 lordship.
No, you are arguing against your own notification.
We cannot dilute lordship, we cannot dilute the UGC required qualification lordship.
That is correct.
Even lordship, Assam government issued 1, 2, 3, 4 and 5 document also lordship. That document cannot survive lordship.
And in this case also, on the basis of this only, you have granted the given.
Lordship, that document as per a law laid down by the Honorable Supreme Court after the P. Susila's case and a letter issued by the central government which has negated the recommendation of the UGC, that document is no value in the eye of law, Lordship. No value in the eye of law, Lordship. We cannot dilute, Lordship. No value in the eye of law. So, Lordship, for that purpose, my Lord may kindly peruse the letter which was issued by the central government. This is in the record, Lordship.
Which?
Lordship, I have already supplied last occasion, 3rd November 2010, Lordship. One single pages is there, Lordship. 3rd November 2010, Lordship. If Lordship permit, I can read it and hand over it, Lordship.
1 minute.
Lordship. Lordship, 3rd November 2010, Lordship. Eh, Roman.
Yes.
Lordship, 3rd November 2010, Lordship. It's a letter issued by the central government, Lordship, as per the provisions of Section 20 of the UGC Act, Lordship. Lordship. At 2, I will continue, Lordship.
You want to continue at 2?
Even
But,
I think
then
better
any
to
other.
finish the matter, man. I don't think any other submission to be made from any of the side.
Otherwise, Lordship may fix any day. Lordship, we will.
Oh, no. My lord,
I have no issue, Lordship. I have
enough
no
is
issue. I am
enough, my
free, Lordship, today. I am free. I have no
because
issue.
this sort of
At any
running
time.
commentary will go on. It will be never ending. my lord.
We are not running commentary, Lordship. We are not delivered
We
running
have seen,
commentary.
we have seen.
We are not delivered, Lordship. The re-hearing was done, Lordship, after concluding the hearing, Lordship. So
Okay.
today we have to, Lordship.
2 o'clock.
Lordship. Oblige, Lordship. Well, Lordship. Thank you. I will try, Lordship. Within
doesn't matter.
I will try. I will try.
Let us conclude the argument today.
Lordship. Today to be concluded, Lordship. Today.
But we also want to see the records.
Lordship.
Why the petitioner was not paid, was not given the marks in that Dalgaon.
Yes, Lordship.
Dalgaon, that records. is-
Lordship. So we will place it. If Lordship direct, I can request it. Place it.
Okay.
Lordship. If Lordship with a record for today, I continue, Lordship.
Yeah, you-
Lordship.
we conclude argument.
Lordship. So, Lordship, before that, 3rd November 2010 central government letter, Lordship. So, Lordship may kindly come to Lordship the affidavit in reply filed by the petitioner, Lordship. In page, Lordship, 234, then it will be easier, Lordship. Page 234, Lordship. Page 234, Lordship. I will read, Lordship, page 234 along with, Lordship, 3rd November 2010 letter, Lordship.
Yes.
Page 34 is the minutes of the UGC, Lordship. It's a 472 meeting of the UGC, Lordship, where they have, Lordship, exempted for the timing, Lordship, MPhil. So, Lordship may kindly come to next page, Lordship. Next page is very important, Lordship. Page 235, Lordship. To confirm the minutes of the 471st meeting of the University Grants Commission held on 12th August 2010. My Lord, may kindly mark it, that date, Lordship. That date is relevant, Lordship. The commission considered the letter dated so-and-so received from the Professor K. Ramamurthy Naidu, Commissioner member, and agreed the following changes, Lordship. Changes is that, Lordship, they have given the MPhil as a in option to the Lordship, net and slate also, Lordship. So, Lordship, my Lord may then kindly come to Lordship. Here, Lordship, last paragraph, just I have read, Lordship. The commission further resolved that since both the above mentioned regulations are prospective and not retrospective in nature, therefore, all the candidates having MPhil degree on or before 10th of July 2009 shall remain exempted from the requirement of NET for the purpose of appointment of lecturers and assistant professor. Further, all candidates who have either obtained PhD degree on or before 31st December 2009 and candidate who had registered themselves for PhD degree on or before 2010-2009 are subsequently awarded PhD degree shall remain exempted from the requirement of NET for the purpose of appointment of assistant professor. This was the resolution of the University's Grants Commission Lordship. This resolution was Lordship 471st meeting of the UGC Lordship, and it was also reiterated in the 472 meeting Lordship. My Lord, then kindly come to Lordship the letter which was I have placed Lordship 3rd November 2010 Lordship. This is the letter issued by the central government under section 20 of the University's Grants Commission Act 1956 Lordship. This letter was issued by the Ministry of Human Resource Development Department, Higher Education Department Lordship. If Lordship permit, I can read it Lordship. First paragraph Lordship. I desire to draw your attention to your letter addressed to the Secretary Higher Education Department 23rd September 2010, in which a request has been made to the government to accord concurrence to the resolution made by the Commission on agenda of 2.08 in the 471st meeting held on 12/8/2010. That is in Lordship, paragraph 235 Lordship. Paragraph 235.
Page.
Sorry, page 235 Lordship. Page 235 Lordship. In this connection, I am desired to convey to you that the said resolution are against the letter and spirit of the regulation issued by the UGC from time to time regarding compulsory net slate qualification for appointment of lecturers and assistant professors. The above mentioned resolution perhaps does not take into account the fact that appointments, if any, pursuant to the date of coming into force of these regulations are bound to be prospective only. Appointments can never be made with retrospective date. Therefore, exempting the candidates from net slate requirement who are going to be appointed or have been appointed after 11th July 2009 would be violative of the UGC's minimum qualifications required for the appointment and career advancement under Regulation 2009 Lordship. Then Lordship, regarding the plea that since proviso to UGC minimum qualifications required Regulations 2000 and remains in force till the notification of UGC's minimum qualifications for appointment of teachers Regulation 2010, and hence UGC can consider and dispose of the application received seeking exemption from the net requirement again is not tenable Lordship. Madam, kindly mark it. This resolution does not take into account the UGC's minimum qualification required for appointment of career advancement of teachers for universities, institutions affiliated to it, 3rd Amendment Regulations 2009 at all, wherein a blanket ban was imposed on non-net slate qualified candidates Lordship. Similarly, since the Commission's own admission, the regulations are prospective in nature and not retrospective, invoking the proviso to UGC minimum qualification dated so and so, Regulation 2010 is clearly incongruous. The present regulation in force do not have any provisions for exemption of candidates who are not net slate qualified. In the above circumstances, I am desired to draw your attention to and reiterated the directive issued under Section 21 of the UGC Act 1956, making net slate compulsory for a teaching position as a policy relating to the national purpose as maintained for standard of higher education Lordship. Against the resolution of the UGC Lordship that was negated by the central government under the power conferred under Sections 21 of the UGC Act Lordship. Central government opined that Lordship, we cannot Lordship lower the standards prescribed for the appointment of the assistant professor or other teaching faculty, where net and slate is the mandatory requirement. The proposal given by the UGC was negated by the central government, and UGC is bound by the direction given by the central government under Section 20 of the UGC Act 1956. Now, Lordship, for that proposition, Lordship, I am relying the P. Susila's case, Lordship. P. Susila's case is there, Lordship. That exemption was Lordship negated by the UGC Lordship, and it was Lordship, and that also Lordship affirmed by the Honorable Supreme Court Lordship. So my Lord may kindly come to Lordship.
Maybe correct. That will be used in the state. Maximum will be exempted.
Yeah, my lord, may kindly come to P. Susila's case, Lordship. Is a 2015 8 SCC 129, Lordship. My lord got it. I already supplied, Lordship.
Yes.
Here, Lordship, I am relying, Lordship. Paragraph 7 onwards, 7, 8, 9, 11, 12, 13. I will read it, just I am mention it, Lordship. And paragraph 23, Lordship. So first, Lordship, I am relying paragraph, Lordship, 7, Lordship. Relevant one is, Lordship, all these paragraphs are relevant. Yes, because, Lordship, there at preceding paragraphs discuss about the UGC resolution, Lordship, and others finding. So, Lordship may kindly come to then, Lordship, paragraph 8, I have started, paragraph 8, Lordship. Paragraph 8 says that, Lordship, the two resolution, which just I have mentioned, Lordship. By the two resolution dated 12/8/2010 and 27/9/2010, UGC opined that since the regulations are prospective in nature, all candidates having MPhil degree on or before 10/7/2009 and all persons who obtained the PhD degree on or before 31/12/2009 and had registered themselves for the PhD before this date but are awarded such degrees subsequently shall remain exempted from the requirement of NET for the purposes of appointment of lecturers and assistant professors. About the two resolution, Lordship. Then, Lordship, paragraph 9, the letter just to which I have mentioned it, the letter, Lordship. Paragraph 9, the central government, however, by letter dated 3/11/2010, informed the UGC that they were unable to agree with the decision of the commission and stated that consequently a candidate seeking appointment to a post of lecturer assistant professor must fulfill the minimum condition qualification prescribed by the UGC, including the minimum eligibility condition having passed NET test. Even state also it is set, NET and set or SLAT, Lordship. Then, Lordship, 11. On the other hand, the Learned Council for the Union of India and UGC stressed the fact that Section 26 regulations have to be made consistently with the Act of Section 20 is very much part of the Act. Therefore, if direction on questions of policy are made by the central government, regulation must necessarily be subordinate to such direction, Lordship. It was also pointed out that if a question arises as to whether a subject matter is a question of policy relating to national purpose, the decision of the central government shall be final, Lordship. They then relied upon so and so, so and so, so and so. Then, Lordship, paragraph 12, Lordship. It is clear that Section 26 enables the Commission to make regulation only if they are consistent with the UGC's Act. This necessarily means that such regulation must conform to the Section 20 of the Act. Under Section 20 of the Act, the central government is given the power to give a direction on question of policy relating to national purpose, which shall guide the Commission in the discharge of its functions under the Act. It is clear, therefore, that both the direction 12/11/2008 and 30/3/2010 are direction made pertaining to the questions of policy relating to the national purpose in as much as being based on the Mungekar Committee report so and so, so and so, so and so, Lordship. Then, Lordship, directly come to, Lordship, paragraph 13 also relevant, Lordship. And, Lordship, directly come to the findings 23, Lordship. I have just shortcut it, Lordship. Just I mentioned the paragraph and 23 is the final, Lordship. We have already pointed out how the direction of a central government under Section 20 of the UGC Act pertain to the question of policy relating to the national purpose. We have also pointed out that the regulation making power is subservient to this direction issued under Section 20 of the Act. The fact that UGC is an expert body does not take the matter any further. The UGC Act contemplates that such an expert body will have to act in accordance with the direction issued by the central government. This is the ultimate findings of the Honorable Apex Court. Apex Court says that you are bound by the direction issued by the central government under Section 20 of the UGC Act. What is the direction of the central government under Section 20 of the UGC Act? It is in 3/11/2010 letters, Lordship. It says that the resolution taken in 471 and 472 meeting of the UGC are not acceptable, as because you cannot exempt the MPhil degree, that's why that resolution was negated, and it was also affirmed by the Honorable Apex Court Lordship. And Lordship, before that Lordship, before passing of the law laid down by the Honorable Apex Court in P. Susila's case, our High Court, exactly similar point, my Lord Justice Ujjwal Bhuiya has laid down the law, Lordship. Exactly same point. That is the direction. It is in Lordship, Biswajit Deka's case, Lordship. Our High Court laid down the law, Lordship, before Honorable Apex Court had, Lordship, decide the issue, Lordship. Here, Lordship, I am relying paragraph 8, 15, 17, and 18, Lordship. The petitioner's name is Lordship Biswajit Deka, Lordship. Here, Lordship, petitioners were selected on the basis of the MPhil degree, which was obtained by the petitioner, that was put to challenge by one of the respondent, Lordship, respondent number 5, before the Honorable, our High Court, Lordship. Then, my Lord Justice Ujjwal Bhuiya has laid down the law, Lordship. Before, Lordship, Honorable Apex Court laid down the law. Our High Court has laid down the law. 8, 15, 17, and 18 paragraph.
8,
Paragraph 8, 15, 17, and 18, Lordship. Doubly vision of title to this one. 4048 Paragraph 8, Lordship. I am reading from paragraph 8, Lordship. The respondent number 345 have filed a common affidavit. Stand taken in the said affidavit is that petitioner did not perform well in the interview. Accordingly, he was awarded lesser marks under the headings of knowledge of subject interview. Overall, petitioner secured so-and-so marks, whereas respondent number secured so-and-so mark. Though it is admitted that respondent number 5 was the guide of the respondent number 9, it is stated that the said fact did not play any role in the selection of the respondent number 9. As per government notification dated 1/1/2011, which was based on the decision of the UGC. My Lord, may kindly mark it. Government notification, that was also there, Lordship, that government notification, Lordship. It is in, Lordship. It is in page 233, Lordship. Page 233 of the affidavit in reply, Lordship. Where government has issued notification on the basis of, Lordship, may kindly, before going to the judgment, kindly come to the Lordship, page 233, Lordship. Page 233, Lordship.
yes.
I am reading, Lordship. It's a government notification that was issued by the government of Assam, Lordship, on the basis of the, Lordship, 472, Lordship, UGC's resolution and 471 UGC's resolution, whereby, Lordship, MPhil degree holders are exempted from the net and slate, Lordship. This was the decision, and the decision taken by the government on the basis of the UGC's decision, Lordship. And that was also reflected in the order, paragraph 8, Lordship. May I read, Lordship, paragraph 8?
Yes.
Lordship. As per the government notification dated 1/1/2011, which was based on the decision of the UGC dated 27/9/2010, all candidates who have obtained MPhil PhD degree on or before 10/7/2009 are exempted from clearing net slate for appointment as a teacher in a college and universities. This notification dated 1/1/2011 superseded earlier government notification 7/10/2009, which required net slate for the appointment. Since the respondent number 9 has completed MPhil course in the year 2008, he was eligible for appointment assistant professor. In paragraph 15, it is stated that as per the guidelines, 1 mark is to be awarded for each of a publication, so and so, so and so. Then, Lordship, come to paragraph 15, Lordship. Paragraph 15.
Yeah.
As per the UGC's minimum qualification required for the appointment of career advancement of teachers and universities institution affiliated regulation 2009, net slate shall remain the minimum eligibility conditions for recruitment and appointment of lecturers in universities, colleges, institutions, provided that candidates who have been awarded PhD degree in compliance of the UGC's minimum regulation 2009 shall be exempted from the requirement of the minimum eligibility condition net and slate for the requirement for appointment assistant professor or equivalent position of the universities college and institution. Then Lordship, paragraph 17, Lordship. May I read, Lordship?
Yes.
The UGC's minimum qualification required for the appointment and career advancement is of teachers and universities institution affiliated regulation 2009 is a statutory piece of regulation framed in exercise of power under clause E and G of subsection 1 of the section 26, read with section 14 of the UGC Act 1956. When a statutory requirement of eligibility is in place, the same can be replaced or substituted only by one having statutory backing. The government notification dated 1/1/2011, on which much reliance has been placed by the college authorities, is based on the resolution of the UGC. Respondents have not been able to show any statutory enactment incorporating such exemption as a part of the UGC regulations. Therefore, such resolution of the UGC has not taken any statutory shape. In absence of any statutory enactment, court is of the view that the eligibility condition as per UGC's minimum qualification required for the appointment and career advancement of teachers in universities institution affiliated to the in regulations 2009 would be applicable in the selection in question. Court is also of the view that paragraph 18, Lordship. Regulations and eligibility requirement which were prevalent when the consideration took place shall be applicable on the date of consideration, that is on interview 29/6/2011. Requirement respondent number 9 did not have net slate, which is the mandatory requirement under the appropriate regulations. That being the position, respondent number 9 did not have the eligibility to be appointed to the post of assistant professor. Thus, his selections and appointment cannot be sustained. Accordingly, selection and appointment of respondent number 9, assistant professor English students, is set aside in class. Here, the respondent number 9 has the qualification of MPhil degree, Lordship. On the basis of that, Lordship, college authority selected him, and he is relying the Lordship that paragraph 233 office memo of the government of Assam, which was issued on the basis of the exemption given by the UGC, and which was also negated by the central government, which was also affirmed by the Honorable Supreme Court in P. Susila's case, Lordship, and that Honorable our High Court says that, Lordship, as because that UGC's regulation is not a statutory shape, it is not binding, so the exemption which was given for net and slate cannot be accepted, and the appointment which was done in respect of respondent number 9 on the basis of the MPhil degree, that was set aside by the Honorable Court. So, Lordship, on the basis of the law laid down by the our High Court and the Honorable Apex Court in P. Susila's case, the government of Assam, Lordship, cannot dilute the UGC's prescribed qualification for the appointment. The UGC's prescribed qualification for the appointment is the net, slate, set, or PhD, Lordship. MPhil is never a required qualification. Although some point of time they have UGC has exempted, Lordship, that was negated by the central government, and it was also, Lordship, the law laid down by Honorable Apex Court. You cannot. This is my submission in respect of MPhil degree, Lordship. The MPhil degree is not a required qualification at any point of time regarding, Lordship, appointment of the assistant professor. And UGC's exemption part is also negated, and it was also affirmed by the Apex Court. Before that, our High Court also set aside the appointment, which was done on the basis of the MPhil degree.
But you have appointed so many assistant professors violating all this.
That part I cannot today. Some wrong was committed, that cannot be repeated. Even Honorable Apex Court time and again reiterated that. Even wrong order was passed by the Honorable Court, that also cannot be taken into account, Lordship.
We have come across till 2000, till that notification was issued. Basing on all this,
That
you have
notification is no value. After the Honorable Apex Court judgment, before that the letter instruction issued by the central government, that notification is no value, Lordship.
but up to 2020, I'm sure I've come across, you
Lord-
have appointed.
Lordship, some wrong was done, that
Not
cannot
so
be,
many wrongs.
even many wrong, is a group of wrong, I can place the judgment also.
See,
Even-
there will be chaos in the service of the assistant.
Lordship, I can say that even 100,000 persons is appointed, Lordship. That cannot be a ground for, Lordship, appointment of other persons, Lordship.
Maybe
We are before the law, Lordship. We
There'll
are
be
before the,
chaos in the state
Lordship,
once we pass the order.
no, Lordship. It is not a chaos, Lordship. The
How will there be no chaos?
lordship, we are not appointing that benefit was given. That the persons whose list
See,
were given.
you are the one who has appointed so many assistant professors, basically violating in all which you are relying
Lordship,
now.
if authority is violating, whether court can permit to violate further it, lordship.
No, not on that.
Lordship,
Practically, where
practically, lordship, from 2017 onwards, there is nothing, lordship. Before that, lordship, some elements is there, lordship. For which, lordship, one committee was constituted by
the judgment was of 2011.
lordship,
And the
2015.
Puspa was 2015.
15.
And till the 2017-18, you have been
Lordship, some wrong was committed by some of the official, lordship. Against that, inquiry was also conducted. Even High Court committee was constituted regarding that benefit was given, lordship. Already it was identified more than, lordship, 200 teachers, lordship. Identified regarding benefit given on the basis of the PhD and MPhil degrees, lordship. That cannot be a ground for, lordship. Here, we are before the law, lordship. We bound by the, lordship, law laid down by the Honorable Apex Court, lordship.
No, we're not saying for a minute also, we're not saying it should be a ground.
Lordship.
We're just,
No, I understand. Even, lordship, that query,
what you have done, we're just,
lordship, this is not the first time I am facing before the Honorable Court. I am facing again and again, lordship. I am admitted, lordship. But that cannot be a ground, lordship. Something wrong was done by some official,
why
lordship.
don't you advise your government?
Already we have advised. On the basis of the advice and on the basis of the direction of our High Court committee was constituted. That committee submitted the report, lordship, on 2022, lordship. And on the basis of that, lordship, now 127 DP is going on, lordship.
Action is being taken.
Lordship, action has been taken. Even if, lordship, allow me, I can place all the findings of the, lordship, expert committee, lordship. It's a high-powered committee constituted. Regarding, lordship, that my lord has pointed out some persons has given, lordship, benefit. On that point, just I have already, lordship said aware that law, just I have 2 paragraph I am reading, lordship. On I will apex to give, lordship, permit, lordship. 2 paragraph, lordship. 1 paragraph from, lordship, I will give the citation, lordship. 2014-15 SCC 715, I'll provide the copy also, lordship.
Negative equality.
Lordship. Only
It's a setup.
it's a settler, just I am reiterating 1 paragraph, lordship.
There's no concept.
Lordship, paragraph
Negative
16,
equality.
even 2023 also, the full bench, 3 judges bench of the Honorable Appeal, I will also there rely, just, lordship, 3 lines, lordship.
2000?
Just 2014-15 SCC 715. It's a paragraph 16. I only relying, lordship, read on 3 lines, lordship. If an illegality and irregularity has been committed in favor of an individual or a group of individual, or a wrong order has been passed by a judicial forum, others cannot invoke the jurisdiction of the higher or superior court for repeating or multiplying the same irregularity or illegality, or for passing a similar wrong order. A wrong order or decision in favor of any particular party does not entail any other party to claim benefit on the basis of the wrong decision. Even otherwise, the Article 14 cannot be stretched too far, to otherwise it would make functioning the administration impossible. And another 2 lines, lordship, other judgment, lordship. 2007 1 SCC 93, lordship. Paragraph 9 and 10, I am relying only paragraph 10, 2 lines, lordship. Merely because in some cases the norms may not have been followed, that cannot be a ground to hold that departure from norms should be continued, lordship.
Anymore? You have crossed 25 minutes.
Lordship. And other judgment, Lordship, three judgment already I have given, Lordship. Our Muthu Kumar judgment is there, Lordship. It's paragraph, Lordship, 24. I will not read it, Lordship. Paragraph 24. Oh, paragraph 24. Now, I am, Lordship, closing my, I am saying that, Lordship, I am concluding, my concluding remark will be, Lordship, the UGC's, the which amendment to be sought by, to sought by the UGC's by 471 and 472 resolution was negated by the central government under section 20 of the Universities Grants Commissions Act, and UGC is bound by the direction issued by the central government, and that was also affirmed by the Honorable Apex Court in P. Susila's case, Lordship, and it was before that also in our High Court Biswajit Das case, that was there, so Lordship. So, Lordship, the MPhil cannot be a, Lordship, minimum required qualification for appointment for the post of assistant professors of any institution under the higher education department. This
But
much.
the applicant has a PhD.
Yes, that part, eligibility part, I have not just, it is pointed out that part, that's why I'm arguing that part. Otherwise, Lordship, the given of marks, it is an admitted case of the petitioners is that as per the appeal memo, page 88 and 89, it's a off-campus, Lordship. It's a public document issued by the concerned university, Lordship. So if it is a off-campus, Lordship, it is covered by our High Court Division Bench judgment.
Other candidates
They were given.
don't qualify.
We'll ask you.
Our High Court Division Bench judgment, as well as, Lordship, the Professor Yaspal's judgment and Kumansol Institute of Technology judgment. In Kumansol Institute of Technology, Lordship, I have already given copies there, Lordship. The
There's one more, 2022. That day, I think this is somewhere here,
Lordship,
Ibardan, 2020.
Lordship. Good.
Ibardan something like. Where it says the regulation framed under the act, it's mandatory.
Lordship. It is, Lordship, just name is Lordship, I am, no, Lordship.
2022.
Gambhidon K Gadbi, Lordship. Gambhidon K Gadbi, Lordship. So, Lordship, as per the Kumansol Institute, Lordship, the institute offered degree within the state of Uttarakhand, but the permission was given to operate only 4 districts. That also Honorable Apex Court says that you cannot operate the off-campus centers beyond the territorial jurisdiction of the 4 districts, Lordship. Even state also not permitted. This is my humble submission, Lordship. Obligation.
Well, just one line point, pointer, I just conclude. Lordship, if it goes to the appeal memo, the prayer of the appellant is to struck down one sentence from the impugned judgment, nothing else. The sentence is contained in the paragraph 10 of the impugned judgment. This is the only prayer from them. So all the remaining argument is null and void. It's not necessary at all. If Lordship kindly see the prayer of the writ appeal, Milord, they want to struck down one sentence from the paragraph 10 of the impugned judgment. Kindly Lordship may make a note, Milord. And apart from that, Milord, they have not sought for any relief from this bench, Milord. Their prayer in writ appeal to struck down one sentence from the paragraph 10 of the impugned judgment. That's it. The rest of the whole arguments are non-existent argument. Not necessary at all, irrelevant.
Yes.
Regarding that part, I have left out, Lordship. My brother has indicated, so I am just relying the one judgment of the Honorable Apex Court, only that part, Lordship. My Lord may kindly note it, Lordship. 2010, only that part, beyond the pair, Lordship. 2010, 1 SCC, Lordship, 234. It's a Bharat Amritlal Kothari's case, Lordship. Honorable Apex Court says that, my Lord, paragraph 29, 30 and 31. 29, 30 and 31, where Honorable Apex Court says that under 226 jurisdiction, if Lordship permit, I can read that 3 paragraphs. Although it is not supplied the copy, if Lordship permit, I can read it. The approach of the High Court in granting relief not paid for cannot be approved by this court. This is the findings of the Honorable Apex Court, Lordship. Every petition under Article 226 of the Constitution must contain a relief clause. Whenever a petitioner is entitled to or is claiming more than one relief, he must pay for all the relief under the provisions of the Code of Civil Procedure 1900. If the applicant plaintiff omits except with the leave of the court to sue for any particular relief which he is entitled to get, he will not afterwards be allowed to sue in respect of the portion so omitted in or relinquishes. Then 30 lawsuit. Though the provisions of the Code of Civil Procedures not made applicable to the proceedings under Article 226 of the Constitution, the general principles made in the Civil Procedure Code will apply even to writ petition. It is therefore incumbent on the petitioner to claim all relief he seeks from the court. Normally, the court will grant only those relief specifically paid for by the petitioner. Though the court has very wide discretion for granting relief, the court, however, cannot ignoring and keeping aside the norms and principles governing grant of relief not even paid for by the petitioner. Then paragraph 31 also Lordship, in Lordship permit I can read it. In Krishnapriya Ganguly's case, overlooking the rule relating to grant of admission of postgraduate course in medical colleges, in his own petition in the High Court, the respondent had merely paid for a writ of direction to the state or the college to consider his case for admission. Yet the High Court went a step further and straightaway issued a writ to the mandamus directing the college to admit him to the MS course and thus granted relief to the petitioner, which he himself never paid for and could not have been paid for also. So Honorable Affairs Court says that if you want to pay something, you have to include it, Lordship. Beyond that, Lordship, even 226 jurisdiction also cannot do it.
May I take your lordship leave, my lord, some other matter. Problem.
So far, the submission made by my learned friend in regard to whether these UGC commission's, my lord, notification, whether it still remains or not. In that regard, my lord, I will require some instruction. Can I take liberty if your lordship takes up the matter on Thursday? Just for 15 minutes.
Thursday.
My-
But Mr. S. Datta, Learned Senior Counsel, assisted by Mr. S. Datta. Huh?
S. Datta.
S. Datta for the appellants. Also heard Mr. K. Gopal, Learned Standing Counsel, Higher Education for the respondents, 1 and 2. And Mr. T. Jamal, Learned Counsel, Learned Standing Counsel, UGC,
Lordship.
for respondent. Stop. We want to see the records. When can you get it?
So I will come back it. I will bring it.
When can you get it?
Thursday I will try, Lordship.
Okay.
Thursday.
Uh,
It was.
List the matter.
Then Lordship, Thursday it will be difficult, Lordship. Lordship may, if
Tuesday,
next
Yes.
Tuesday.
19th.
And
My lord.
List the matter on 19th.
whether my lord is available here.
Yes.
My lord is available.
It's not here.
His lordship will not be there.
No.
As convenient to his lordship.
After 2 weeks, no? So- 2nd April.
Lordship.
We'll try.
My-
Your rooster has not come out,
Yes.
so we don't know. But then hopefully after 2 weeks he'll come back.
Lordship.
My lord, your lordship can pass a writ so that his lordship be here.
What did I say?
Do it, do it.
Mr. matter on 2nd April
2nd April.
as part of on which date the Learned Standing Council, higher education, isn't it? Shall higher education
Lordship.
shall produce the records.
Much obliged.
Written argument also given.
এইটো ৰেকৰ্ডটো সেইটো কৰিব লাগিব নি? ৰেকৰ্ডটো এনেকে-
Okay, written argument also you submit them on that day.
There is the biggest problem.
Written argument.
Lordship.
Zero. My lord, item number 10 to 15, and item number 13, I'm appearing for IWT. My lord, I've been informed that Mr. P. Nayak for finance will not be available today. The matter may be adjourned, my lord.
On his behalf,
My lord.
you are appearing for the petitioner?
No, my lord, for the respondent.
Anybody appearing for?
I am for a petitioner in item number 13.
Yeah, Mr.
RB Goswami.
Datta, M. Datta. Amicus Curie,
Not there.
I think 13 amicus curiae is not there. The three-
Mahmood, MU Mahmood. Yeah, Buyan,
I think 13 they are there. We have informed. that it-
third Mr.
K Kolita.
K. Kalita, learned counsel for the petitioner in WBC 2194 of 2013. On request made on behalf of Mr. P. Nayak, learned standing counsel,
Finance man.
Finance Department. When do you want?
My lord, 4th of April, my lord.
List the matter on 4th April. Item 10 to?
15, my lord.
Okay. Yes.
My lord, I am paying adjournment item number 7 and 8, my lord.
Why?
Next week, my lord.
Okay, on request made by K. Kalita, learned counsel for the petitioner. List the matter on. When do you want?
My lord,
After 2 weeks.
22nd,
The 2023 matter after 2 weeks.
then my lord, 27.
Not 26. After 2 weeks we'll have.
Oh, Lord.
May I please, Your Lordship?
Hmm.
Lordship, I beg to mention item 17 of today's list, my lord. Lordship,
Yes.
Mr. Dipankar Bora appears in the matter, my lords, today because of some personal difficulty. He could not appear in the matter, my lords. I'm seeking a short accommodation only for today, my lord.
Who's the Dipankar Bora?
Dipankar Prasad, he's the standing counsel for the health department, lord.
Okay.
I am
you
for a
have
petitioner, my lord. I
You
am
have
for a
any
petition.
objections?
Yes, Botak, my lord. Next week, my lord, any date, my lord.
Okay. Third, Mr.
Yes, Botak, my lord.
S. Botako, learned counsel for the petition. On request made on behalf of Mr.
Dipankar Prasad Bora, DP Bora.
Okay, DP Bora, learned standing counsel health department. List the matter again on.
Lordship, as per Lord.
Next week, my lord, any date, my lord.
I need it.
Okay. 19th,
On 21, my lord. 19, my lord.
21, 21.
Lordship, item number 18 also, Lordship, a similar prayer because Mr. DP Bora appears in the matter, Lordship.
BT Goswami,
Lordship, Mr. BD Goswami has been informed, Lordship, but he was supposed to be appearing, Lordship, but Lordship, only for the day, my lord. Short date may be fixed, my lord.
okay, on request made on behalf of Mr. DP Bora,
Yes, my lord, that's,
learned standing counsel health.
yes, Lordship.
List the matter again on. 19th.
Lordship.
Meet please, Your Lordship. I would like to pray for listing of a writ petition, my lord. It's a motion matter on Friday, my lord, 15th.
Why, what urgency is there?
We are qualified RCCC trainers. It's a post of lot model,
Hmm.
but in spite of us, the government is giving we are not given the opportunity to appear in the examination, my lord.
Why?
A new rule has been established, my lord, but we are governed by 1992 rules. But a new rule has been introduced, and it's a 2023 rules, my lord.
Monday,
Friday, my lord.
Monday, 18th.
All right.
Yes.
Lordship, I pray for listing of a writ petition or motion on Friday, my lord. Urgency is that, my lord, petitioners, they were appointed as district program manager under the National Health Mission, my lord. And that post was not transferable, my lord. But on 6th of this month, my lord, the department has issued a transfer order. Assailing that order, we have filed this writ petition, my lord, and they have to join their service on Monday, my lord. So may I pray that it will come up on Friday, my lord, if possible, my lord, for motion, my lord.
Okay.
Obliged, my lord.
20 of supplementary list withdrawal.
Yes,
May it please, Your Lordship, my lord.
yes.
My lord, order is complied here, my lord. Subsequent cause of action is arising, my lord. Now kindly close the matter, my lord.
Mr.
HP Gwala, my lord.
SP
Gwala.
Gwala, learned counsel for petition submits that the respondents have complied
My lord.
with the order passed by this, with the directions passed by this court. Stop. Accordingly, this contempt petition is closed.
Obliged.
One of daily list motion.
Make leader lawsuit.
Hmm.
Last occasion, government wants to please, whether my
Yes, Mr.
petitioner, yes, my lord.
Has it been considered?
Maybe dispose of directing this next DLC.
Has it been considered or not?
Not received, my lord. Instruction not received.
No, my lord, actually, my prayer is that my name shall be sent to the district
No,
level
that's right.
committee. Yes.
Whether the
I had
DLC
letter
has
period
considered.
February, but not received. instruction.
Heard Miss MS K Devi London Council for petition. Also heard. You have 4 respondents,
1, 2, 3.
RK Mushari, London Standing Council BTC, 4 respondents, 1,
2, 3.
2,
No.
3,
2 and
Yes,
3.
1, 2, 3.
no, 4, 5 also. Maybe. To me, 4 and 5, Mr.
Mr. CKS Barrow, London Government Advocate, appraised for respondents, 1. Para. The petitioner's father, late Chanti Prasad Thakuria, while working as Lot Mandal in the circle office, Bishni Revenue Circle, Chirang district, died in harness on 22/12/2010. Is that correct? 22/12/2010.
10.
Thereafter, the petitioner met an
Applied.
application for appointment on compassionate grounds on 11/3/2011. Stop. The grievance of the petitioner is that his case has not been placed before the concerned district level committee for consideration on commissioning grounds. For consideration, for appointment on commissioning. Stop. No, cancel that. To cancel that grievance. As no steps were taken. The petitioner made repeated applications. Which for placing his or her his case before the concerned DLC. However, as no steps were taken forward. The petitioner filed WBC number 502 of 2015, which was disposed of by order dated 6/5/2015.
2015.
2015. On the basis of an affidavit in opposition filed by the respondent BDC, wherein it was stated that the application of the petitioner will be considered by the district level committee in its next meeting. On the basis of such statement, the said writ petition was dismissed, was disposed of. Directing the respondents to consider the case of the petitioner for compassionate appointment in its next sitting. Stop. Para. The grievance of the petitioner in disposing of petition is that despite the assurance given by the respondents that his case would be considered in the next DLC meeting, the case of the petitioner has not been considered till date. Stop. Para. After hearing parties, and on perusal of the materials available on record. This writ petition is disposed of. Directing the respondents, particularly
Particularly respondent number 3,
respondent number 3,
Director.
the the Director Land Records and Survey, Butuland Territorial Council, Kokrajhar, to place the case of the petitioner before the next immediate sitting, before the concerned DLC for consideration of the case of the petitioner in its next immediate sitting. Stop. Full stop. However, if the case of the petitioner has been considered, the outcome of such consideration shall be communicated to the petitioner forthwith with the above observations and directives.
Oblige, Your Lordship.
To admission.
It is your lordship. My lord, the matter was heard by your lordships earlier.
Oh.
Practically, my lord, Mr. D. Gogoi appearing for the forest department had considered that they don't have anything much to say in the circumstances of the case. The fact remains that the petitioner was granted VRS in the year 2012. And thereafter, after a lapse of about 12 years, 11 years, my lord, the department wants to proceed against her on the ground of disciplinary proceeding. So whether they can do it or not. Otherwise, I'll just place only 3 decisions for your lordship's consideration, my lord, that your lordship may take into account. And there is absolutely no explanation as to why they sat over the matter for 10 years. And right from the case of Bani Singh, my lord, 1992 Supreme Court, the consistent view of the Honorable Supreme Court has been that if there is a delay and there is no explanation forthcoming, that the DP has to be quashed. So that is the precise point in the case, my lord, and therefore, I'll today.
Who is Gogoi? You are praying for on behalf of Gogoi? Are you taking up the
On the
matter?
last occasion, we had produced an instruction, the only written instruction we received from the department, which says that the action was done pursuant to a view taken by the judicial department. That must be with your lordship's records. We produced it in the last occasion.
That was dated 14th of
That
February.
is the
2000.
only written instruction we received, lordship.
Yes.
Well, they had got, these are the only 2 decisions that I will place before your lordship so far as the question of
Your case is that you applied for VRS, it was granted.
it was
to you.
granted. And now after 12 years, my lord, they want to, since I made a demand for payment of my pensionary benefits and all, now they want to stall that process. Now they want to proceed against me department.
Where is that order?
That order, your lordship will find the impugned order. At page 70.
Your VRS was granted.
My VRS was granted in the year 2nd November 2012, page 61. Second November 2012, page 61. That was when the VRS was granted, and this page 70, page 21 is the impugned order. Sorry, annexure 21 is the impugned order.
Yes.
Page 70. So now after, since in between I made representations demanding release of my pension and other benefits. In fact, there was a writ petition pending before this honorable court, and in which the relief of pension and other things were sought. And there they took this plea that now some order has been passed and therefore they want to proceed against me departmentally. So in that circumstance, my lord, the writ petition was withdrawn with liberty to file afresh. That is how this present writ petition has been filed. Well, Lord, my simple submission on this point is that, my lord, there is no affidavit coming, and even in the order, my lord, there is no explanation why they took 10 years to sit over the matter.
One affidavit is there.
No affidavit has been filed. Only one affidavit has come from the side of the respondent number 8. They only say that whatever they have done, that is in pursuance of the opinion of the judicial department.
Who's respondent 8?
Yes. Respondent number 8 is
Yes.
the administrative department. They only say that whatever they have done, that was pursuant to the opinion of the judicial department. And that is the same stand taken even by the forest department. Now, in the written communication that was sent, my lord, the copy of which has been shared by the respondents' counsel on the last date, 14th of February 2024. So that is the only thing coming over. So practically, my lord, there is no explanation as to why it took so long.
Which para is it? In
Now-
that affidavit in opposition of respondent 8.
In the respondent number 8, your lordship will find at page 84,
Oh.
paragraph 6. That with regard to the statements made in the paragraph so of the department begs to state that PNPG department, being a referral department, can only offer its views on pension matters if administrative department seek views sending the proposal file. In the present case, no proposal under Rule 54 of Assam Service Pension Rules is received from the Environment and Forest Department till date. And that is the only stand. The rest are all no comments as being matter of record. So practically, there is no explanation from any of the parties as to why there is a delay and what are the reasons. So in that, taking that view of the matter, my lord, that's why I said, my lord, the two decisions that I will be placing for your lordship's consideration.
One decision will do, I think.
So that is, my lord, I'll just read out the paragraph 4 of 1990 Supreme Court, my lord. (1990) Supreme Court, 1308, Bani Singh versus State of MP. The appeal against the order dated, paragraph 4, next page. The appeal against the order dated so and so has been filed on the ground that the tribunal should not have quashed the proceeding merely on the ground of delay and laches and should have allowed the inquiry to go on, decide the matter on merits. We are unable to agree with this contention of the Learned Counsel. The irregularities which were the subject matter of the inquiry is said to have taken place between the years 75 and 77. It is not the case of the department that they were not aware of the said irregularities, if any, and came to know it only in 1987. According to them, even in April 1977, there was doubt about the involvement of the officer in the said irregularities, and the investigations were going on since then. If that is so, it is unreasonable to think that they would have taken more than 12 years to initiate the disciplinary proceedings as stated by the tribunal. There is no satisfactory explanation for the inordinate delay in issuing the charge memo, and we are also of the view that it will be unfair to permit the departmental inquiry to be proceeded with at this stage. In case there are no grounds to interfere with the, in any case, there are no grounds to interfere with the tribunal's order, and accordingly we dismiss the appeal. The original application was filed before the tribunal challenging the charge memo, and that was interfered with. That order of the tribunal went before the Honorable Supreme Court for consideration. And the next judgment also, the same principle is reiterated. Paragraph 12, your lordship may kindly see. Paragraph 12, the very same ground has been specifically raised in this appeal before this court, wherein it is stated that the delay of more than 10 years in initiating the disciplinary proceedings by issuance of charge memo would render the departmental proceedings vitiated and that in the absence of any explanation for the inordinate delay in initiating such proceedings, of issuance of charge memo would justify the prayer for quashing the proceedings as made in the writ petition. Paragraph 15 thereafter, about seventh line in paragraph 15, it is now stated that the appellant has retired from service. There is also no acceptable explanation on the side of the respondent explaining the inordinate delay in initiating departmental proceedings. So and so counsel for appearing for the respondent, his submission is that the period from the date of commission of the irregularities by the appellant to the date on which it came to the knowledge of the housing board cannot be reckoned for the purpose of ascertaining whether there was any delay on the part of the board in initiating disciplinary proceedings against the applicant has no merit and force. The stand now taken by the respondent in this court in the counter affidavit is not convincing and is only an afterthought to give some explanation for the delay. Under the circumstances, we are of the opinion that allowing the respondent to proceed further with the departmental proceedings at this distance of time will be very prejudicial to the appellant. Keeping a higher government official under charges of corruption and disputed integrity would cause unbearable mental agony and distress to the officer concerned. The protracted disciplinary inquiry against a government employee should therefore be avoided, not only in the interests of the government employee, but in public interest, and also in the interest of inspiring confidence in the minds of the government employee. At this stage, it is necessary to draw a curtain and to put an end to the inquiry. The appellant had already suffered enough and more on account of the disciplinary proceedings. As a matter of fact, the mental agony and sufferings of the appellant due to the protracted disciplinary proceedings would be much more than the punishment. For the mistakes committed by the department in the procedure for initiating disciplinary proceedings, the appellant should not be made to suffer. That was the principle on which, Millard, this was. Now here also, Millard, for whatever reason, even the reasons are not coming. Why did they set over the matter for so long? Nothing is disclosed. And the order of retirement, your lordship has seen, it was 2012. So therefore, my lord, my humble submission is that the petition should be allowed. And as far as their contention in the impugned memo that there was an unauthorized absence, that they should regularize and release my pensionary benefits.
Heard
That-
Mr. M. Datta.
Yes,
S. Datta. Leonard, Senior Counsel. Assisted by MS
Aidas.
Ardas.
Aidas.
Aida, Leonard Counsel. for the petition. Also heard Mr.
I Bhattakur on behalf of D. Gogoi,
I. Bhattakur, Leonard Counsel, appearing on behalf of Mr. D. Gogoi, Leonard Standing Counsel,
Forest and Environment.
Forest and Environment Department. Any other respondents? As well as Mr. A.R. Talukdar. R.K. Talukdar. Leonard Counsel, Leonard Standing Counsel, Accountant General for the respond number 6, and Mr. C.K.S. Barwa, Leonard Government Advocate for the respondents 7 and 8. Para. The petitioner, while serving as research and education officer in the Forest Department, was given voluntary retirement by a notification dated 2nd November 2012, issued by the Principal Secretary to the Governor of Assam, Environment and Forest Department. Stop. A disciplinary proceeding was pending against the petitioner. No. while the voluntary retirement was granted to the petitioner, comma, a disciplinary proceeding was pending against him or her,
Her.
against her. And a show cause notice was also issued in the year 2010. Stop. As the pensioner benefits and monthly pension of the petitioner was not settled despite a lapse of many years. The petitioner approached this court by way of WBC number 3311 of the 2022 for release of her pensioner benefits and monthly pension. Stop. During the pendency of the said writ petition, it was informed before this court that the respondents had issued a notification dated 5th April 2023. Correct?
Yes, my lord.
Issued by the Secretary to the Government of Assam, Environment and Forest Department. No, it was withdrawn, isn't that first it was withdrawn?
No, 5th of April is the order.
Oh. By
5th
which,
By which the proceeding is recommenced, sought to be recommenced.
and your voluntary retirement was withdrawn?
No, it was not withdrawn. It was,
And by which the disciplinary proceeding against the petitioner.
the withdrawal is, my lord, that is annexure 20, page 69. Annexure 20, page 69 is the withdrawal order.
Oh, that's why I'm saying. So it was during the pendency of the writ
Yes,
petition, this
yes.
order was
Yes, yes.
during the pendency of the said writ petition. It was informed before this court that the Department of Environment and Forest Department by notification dated 12 September 2022 had withdrawn the voluntary retirement granted to the petitioner by notification dated 2/11/2010. Stop. Drafted by notification dated 5/4/2023. The disciplinary proceeding against the petitioner was
Recommenced.
recommenced. Stop. Where is that withdrawal order of the writ petition?
Withdrawal order is page 72.
Accordingly, comma, the petitioner withdrew the order that writ petition dated writ petition number 3311 oblique 2022. No,
With
accordingly, this court by order dated 26/4/2023 permitted the petitioner to withdraw the writ petition number 3311 oblique 2022 with liberty to file afresh. Para. The present writ petition has been filed challenging the notification dated 12 September 2022 and the notification dated 5th April 2023 on the ground that as the petitioner has been granted voluntary retirement with effect from 2/11/2012, the withdrawal of the voluntary retirement by the notification dated 12 September 2022 and the recommencement of the inquiry against the petitioner by the notification dated 5th April 2023 is illegal and not tenable in the IOP. Stop. The Department of Environment and Forest Department, the Environment and Forest Department has failed to file any counter affidavit. Stop. The respond number 8. Which department is this?
That is administrative department, pension and administrative department. Pension and public grievances.
Pension and public.
Administrative reforms, training,
the
pension and public
administrative
grievances.
reforms, training, pension and public grievances has filed affidavit. Wherein it is stated that the PNPG department, being a referral department, can only offer its views on pension matters if administrative department seek views, sending the proposal in the file. Stop. The relevant portion is reflected in, is stated in paragraph 6, which is reproduced here and below. Page 84, A to A. Stop. Para. The Learned Standing Council Forest Department has no explanation as regards, with regard to the delay in recommencement of the disciplinary proceeding against him, nor with regard to the withdrawal of the voluntary retirement against the petitioner. In fact, the Learned Standing Council relies on a communication dated 14/2/2024, written by the Undersecretary to the Government of Assam, Environment and Forest Department, and submits that subsequently it was found that there were some anomalies while granting the VRS, and the views of the Judicial Department were sought for, and the Judicial Department advised to withdraw the VRS. Stop. The communication dated 4/2/2024, 14/2/2024 is reproduced here in B to B. Para. A consideration of the affidavit in opposition filed by the respondent number 8, as well as the communication relied upon by the communication dated 14/2/2024, relied upon by the Learned Standing Council, does not give any reasons as to why the voluntary retirement of the petitioner was withdrawn by the notification dated 12 September 2020. Stop. Further, there's also no explanation as to why the disciplinary proceeding was recommenced against the petitioner by the notification dated 5th April 2023. Stop. It is more than how many years? More than 10 years after the voluntary retirement was granted to the
Granted.
petitioner that the respondents have taken a decision to withdraw the said voluntary retirement and to recommence the disciplinary process. This is not acceptable in the this is not acceptable before this court. And no, don't say like that. There's no plausible explanation given by the respondents with regard to the action taken against the petitioner. White notification dated 12 September 2022 and 5th April 2023. Stop. This court is of the paragraph. This court is of the considered opinion that permitting the respondents to proceed further with the departmental proceedings against the petitioner at this belated stage would be prejudicial to the petitioner and would not be in the interest of justice. In that view of the matter, the notification dated 12 September 2023, by which the voluntary retirement granted to the petitioner was withdrawn.
12 September 2022.
12 September 2022. And the notification dated 5th April 2023, by which the departmental proceeding against the petitioner was recommenced are set aside and quashed. Stop. Para. The respondents, particularly the officials in the forest department, are directed to regularize the period of absence of the petitioner from
By grant of extraordinary leave, but according to us, my lord, that is from 16th of February 2005, page 25, your lordship may see, page 25. 16th of February 2005 to 20th of March 2012.
anyway, there may be some disputes between the periods.
It's because their dispute is only with regard to the fact that now that they have withdrawn the order of voluntary retirement, so they are extending that time. They are including
The
that.
period of absence
Lordship, that may be verified by the department.
of the period of absence of the petitioner when he was serving as
Wildlife Research
wildlife
Research and Education Officer.
research and education officer shall be verified by the officials, by the concerned respondents, and thereafter the same be regularized by way of
Extraordinary leave.
by way of granting extraordinary leave. Thereafter, the pension papers of the petitioner be prepared and be prepared and the pension papers of the petitioner be prepared. Be prepared
And the pensioner benefits be released.
and the pensionary benefits and monthly pension of the petitioner be released at the earliest, but not later than 2 months. 2 months from the date of receipt of a copy of the order of this court. With the above
Deeply obliged.
clarity.
Three,
May I please, Lordship?
Here, Lordship, I appear on behalf of the PHA department. we were asked to file affidavit on a certain factual aspect. Lordship, we would like to submit that the law of regularization of workers is very clear. They are not entitled to regularization at all, Lordship, as per Upenda's judgment. They can be given certain benefits, but Lordship, not regularization. And it is there.
So are you filing your affidavit or not?
Lordship,
We can file the affidavit, Lordship, if
It's
required.
your choice. If you want to file your affidavit, you file. If you don't want the affidavit, you don't want to file, we'll proceed.
Lordship, they have not filed affidavit since 2021. Numbers of time they were granted to file affidavit.
Everything is clear in the affidavit filed by Finance Department because they are the
Finance
authority
Department has
to
filed their affidavit,
finally pass
Lordship.
an order of regularization. Lord.
And also, Lordship, on the last occasion, they were directed to take instruction whether petitioner's name were forwarded for regularization, Lordship, along with other employees
That part
in
is
2011.
not relevant, Lordship, because in Upenda's judgment,
No,
it has
that
been
doesn't-
category held that attempts were made by state governments in 1993, 2005 to regularize. However, those were not permissible and leave of the court was sought in a miscellaneous case, which is recorded in Upenda's judgment, where court declined to allow that prayer. And because of the restrictions imposed by the Uma Devi judgment, because candidates who have not been through open process, they cannot be regularized. Only certain exceptions were laid down, Lordship.
Yes.
Lordship, that means petitioner's case was not forwarded for regularization, Lordship. Otherwise, they were entitled to regulation, Lordship, 1/4/1993 as per the policy decision.
So are you
They
willing
were
to proceed today?
Yes, I'm willing, Lordship.
Chalia?
affidavit. As per the Finance Department affidavit, Lordship, the workers employees were regularized at that time, Lordship. But the petitioner's name were forwarded or not, they were not aware of. And this instruction was sought for in the last occasion, whether petitioner's name were forwarded at that time or not. And in 2011, Lordship, they were reverted
So
to,
that's the affidavit we wanted from you. Whether the name of the petitioners were forwarded, that's all. If you can't file your affidavit, that's a different.
We'll file it in 1 week then, Lordship.
Okay. I've heard MSR David and counsel for petitioner. Mr.
I brought her to
I Potako.
Yeah.
Learners counsel
On behalf
actually
of
on behalf of
T.N.
Mr.
Goswami.
D.N. Goswami, Learner Standing Council PhD Department. It's allowed a week's time.
Lordship,
File counter affidavit.
last opportunity, already numbers of time, last opportunity was granted.
Last,
to the-
it's after one.
Date may be fixed, Lordship.
One date is what, 1st April.
Obliged, Lordship.
4.
My lord, this case, the petitioner is challenging, my lord, the promotion of the denial of promotion to the petitioner to grade E6. My lord, I think the selection record will be necessary, whether selection records are available, my lord.
Who appears?
I appear, my lord.
You have the records?
Yes, sir, DPC minutes are there. DPC minutes are the record. Yes.
You have it.
I don't have it right now, but Lordship may be pleased to pass an order that will help us. Because normally, my lord, over there, they say there is no order of the honorable court. So
No, my lord,
if my lord passes an order, that will be better.
my lord, the problem is, my lord, the next DPC is due in April.
Yes.
So therefore, my lord, before that, it has to take place.
Yes, sir, Lordship will order, so we'll bring it.
You are bring for the
NHPC,
NH?
NHPC, National Hydroelectric Power Corporation.
No, my lord, if a respondent in a certiorari proceeding, they did not bring the record, then that is to their peril, my lord. Why, when the rule is issued, the idea is to transmit the record before the court. Anyway, it is to up to them, my lord.
Can you take it, produce in a week's time?
Yes.
Yes, my lord, we'll do.
Okay, heard Mr. Kian Chowdhury, Leonard Senior Counsel assisted by Mr. Arun Dekar. Leonard Counsel.
আজি কি বার?
12 তারিখ।
Mr.
অহা 19 তারিখে লোনি বহুত কেস আছে।
PK Tiwari.
KDURA, senior counsel, appearing on behalf of the NHPC shall produce the DPC. Shall produce the records of the DPC.
Yes, yes.
List down, keep a date. Today is 12th, 19th. Would it be on 20th, my lord? Because there is another parted matter on 19th. So if that continues, it will be difficult.
My lord, could it be on 2nd of April, my lord?
Very-
Second of April,
So that is,
Let it-
you are saying that there's going to be a.
Second
DBC
of
in
April also is, my lord.
You're
Second
saying
of
there will
April.
be a DBC in April, isn't it?
Yes, yes. So
Second
it has to be
April.
before that.
So 2nd April.
My lord, kindly have it on 18th, my lord. We'll see, my lord. It's a
May
Monday.
not 18th.
19th, actually, I have got lot many matters, my lord. That's why.
Yes.
Yeah.
18th, Lord, could it be, otherwise, it could also be on, this whole holidays, this period.
Anyway, let it be on 2nd, my lord.
Second is better. I don't think it will.
Anyway, my lord, if I succeed, I'll get a review DPC even from.
Yes, that's it.
earlier.
Yes. In any case, my lord, if they succeed, there has to be review DPC only. Can't be anything else. Second.
5,
May please, your lordship. Your lordship, this matter may be passed over for the day, your lordship. The arguing counsel is absent due to some personal
Who's the
difficulty.
arguing counsel?
M. Ahmed, your lordship.
On request made on behalf of Mr. M. Ahmed and the counsel for the petitioner, is up to 2 weeks.
Final.
Let's not play here, my lord. I think it will be better for future. The respondent should understand certain things. I had told them that in a certiorari proceeding, we need the records. So, my lord, an observation of this nature, it's a certiorari proceeding, and respondents are expected to have the records. Would help me in future also. Okay. Because they don't understand the technicalities. They keep on saying there is no order of the honorable court. So it's difficult. It becomes difficult at times. We'll see on the next. Yes, yes, very well.
6,
Lordship, here matter relates to appointment in the post reserved
this
for.
matter will take some time, lordship. Can it be on
PWD
18th,
category.
lordship?
15. Okay.
MSRDV London Council
For final disposal, Lordship.
on request made by Mr.
The Upamani,
D. Upamanian and the Standing Council,
Health Department,
Health Department, Mr. Metro,
18th.
18 or 19?
Not 19. 19. It's some
You have some difficulty?
Lordship.
18, I have a lot of cases.
Thursday, Lordship.
How about 20?
Thursday, Lordship.
21st.
20. Obliged, Lordship.
9,
Lordship, for this miscellaneous application has been filed by the applicant for restoration of the review petition, Lordship.
When was it dismissed?
24/5/2023, Lordship.
Page.
Page 37, Lordship.
37.
You didn't take notice upon the respondents.
Yes, Lordship.
You didn't take, you never took steps for service of notice.
Yes, Lord.
You were given 2 chances.
Yes.
Then you don't appear.
Yes,
Then why should we restore this?
I was not on record, Lordship. I am the newly engaged counsels, Lordship. That's why.
But after a year, they have,
Yes, Lordship. That is correct, Lordship.
after 1 year almost, your Lordship.
When did you file your review, your miscellaneous case?
This one, Lordship, instant one. 5/3/2024.
5/3. What is the period of limitation? $30.
Review petition, Lordship, that was
That was dismissed on 24/5/2023.
24/5, Lordship.
Then this is barred by limitation, your MC.
May allow me to file condonation petition, Lordship, at this stage. Lordship, otherwise he will be prejudiced.
This is one we discussed. Huh? By which order? Just one? Huh? Counsel,
Yes. I've got. for
earlier
the-
you filed a miscellaneous
also the-
application,
Earlier also they have filed, Lordship, that is
which was withdrawn,
withdrawn, that was not pressed, Lordship, page 40,
it
Lordship.
was not pressed,
Yes, Lord.
and accordingly it was dismissed.
For not
Correct.
pressing. Yes, Lord. I have annexed that order also. Lord.
As not pressed.
What
Now,
will be
where's the scope for filing filing another one? Where's the scope? You have withdrawn as not pressed and it was dismissed. Where's the scope? For filing a fresh review, fresh restoration application.
Lordship, may allow me 1 week time, Lordship, so I can obtain instruction, Lordship.
You take instructions, you don't need instructions, you are a counsel. You know better,
Yes, Lordship, that's.
you know the law. When you file an application for restoration of the review petition,
Yes, Lord.
you withdraw it, saying you withdrew it as not pressed. Then today again you file another misapplication for restoration of the same review petition. What instructions do you want?
May allow me 1 week time, Lordship, so that I can obtain instructions.
Here, Mr.
MK Bora.
MK,
Bora.
on request made by MK Bora, list after 1 week.
Yes. Obliged, Lord.
21 of supplementary list order. May it please your lordship. Lordship, as per Loajima court order dated lordship 11/24, service is complete lordship in respect of respondent number 4 to 92 lordship.
4 to 92.
Yes, lordship.
How do you know that the notice has been completed?
As per lordship Loajima court order lordship. 11/24 lordship.
That we have seen. But it will be difficult to accept this. Four to 92 all in one day they've been served. How can it be? Why don't you go for a substitute service? Okay. That would make your work easier. Respondent 4 to 92 served in one day. Notice.
Lordship, address is
Can you accept that?
lordship, we have given the address General Administration Secretariat Nozor Department lordship block A.
So how do we know that it has gone to them? It has gone to the address in the care of General Administration Secretary Nazarat, right?
Yes, lord.
How do we know that it has been served on them?
Yes, lordship. Lordship, kindly allow us to paper publication lordship.
That's what I'm saying. Paper publication will be better. Mr.
J. Hatimoria.
J. Hatim Muria, learned counsel for the petitioner. Praise for taking fresh steps for service of notice on the respondents 4 to 92 by substitute service. Praise the Lord. The petitioner or petitioners? The
Petitioners, Lordship.
petitioners are directed to cause service of notice on the respondents 4 to 92 by publishing the same in 2 local newspapers having wide circulation in the state of Assam. Within bracket, 1 in vernacular and 1 in English, showing the returnable date as 29th of April 2024. Stop. Draft petitioners shall file an affidavit to that effect. So, list the matter on what did I say? Returnable date 29, no? 29th April 2024.
Right, Lordship. 16 of daily hearing.
May I proceed, my lord?
Yes.
May I please your lordship?
What is this matter?
My lord, this pertains to inaction and gross negligence of the respondent authorities in paying due consideration as well as post-retirement benefits to the petitioners who had rendered dedicated service to SSB. Well, may I proceed? ma'am?
Oh,
Lord,
are
in
you
order,
ready?
Yes, yes.
my lord, in order to place the facts and a little bit of background, my lord, may I read some of the relevant paragraphs of the petition?
Of writ petition.
Yes, my lord.
Okay,
Page 3, my lord.
yes.
Paragraph 1. This instant petition is filed jointly challenging entirely the inaction and gross negligence of the respondent authorities in paying due compensation as well as post-retirement benefit to the petitioners who had rendered dedicated service to the Sashastra Sima Bal Organization SITB intensive trained volunteers and WATS Women Advanced Training School volunteers. The respondent authorities have failed to formulate any schemes in this regard, which is absolutely unreasonable, arbitrary, they being a part of the welfare state. The
So
petition,
they don't have a scheme.
no,
Lordship, subject to what my friend says, he is seeking for retirement benefits, service benefits. Let him show the appointment.
Show the
Appointment letters. Lordship.
that's why I would like to place the
Where
facts,
are
my
the
lord, the
services?
background of this petition, my lord. As the lordship is known to the aware of the backgrounds, my lord. It will be easier to adjudicate the matter. Under what circumstances
you're recruited as ITV,
Yes, my lord.
India SSP,
ITV, my lord,
India,
Inten- intensive trained
volunteers,
volunteers.
India SSP.
Yes, my lord, SSB.
Which year?
My lord, that's why I would like to place the facts, my lord. Right. My lord, kindly come to paragraph 2, my lord.
Yes.
That the Sashastra Sima Bal SSB is an organization under the Ministry of External Affairs of the Government of India. The said organization was formed at the time of the Chinese aggression in the year 1961. The said organization was initially known as Special Security Branch, and thereafter the name was changed to Security Service Brotherhood, and finally to the present names, the Sashastra Sima Bal. The object of the organization was to have constant monitoring and intelligence information by involving civilians who are trained for the purpose. In course of time, the duties of the volunteers were
not only limited to give information relating to external organizations, but also matters relating to the internal disturbances, smuggling and other nefarious activities in various areas, including Indo-Nepal and Indo-Myanmar border. That your petitioners were recruited as members of the SSBS ITB, that is Intensive Trained Volunteers, and WATS, that is Women Advanced Training School Volunteers. Petitioners had to undergo rigorous training for the aforesaid purposes. They were taken to Haplong in the district of NC Hills and other places also to undergo such training. The training consisted of the training consisted of inter alia, rock climbing, trekking, and various associated activities. Few of the petitioners were granted certificates in this regard. My lord, there is no specific date for appointment, my lord. They were recruited in different times, my lord.
At least give the year.
Yes, my lord, in the previous,
How many petitioners are here?
here are only 3 petitioners, my lord,
At
as
least
a
3
representative.
petitioners, what is the difficulty to give the year at least?
My lord, if I place the background, my lord, lordship will understand, my lord. Because there was previous round of litigation, my lord. And there was specific order for framing a schemes, my lord, and direction to the Ministry of Home Affairs. And the Ministry of Home Affairs did not implement the order, my lord. That's why I would like to place the facts, my lord. The operative portions of the earlier judgment, my lord. Let me read out the other relevant portions, my lord. The petitioners were also trained in armed combat. It may be mentioned that the petitioners who were ITB, their training was in Haplong areas. Those who were WATS volunteers, their training were at Bogribari in the district of Gwalpara and Devendra Nagar in the district of Sonitpur. After training of the petitioners, motivation camps were held under the supervision of Indian Army and CRPF at regular intervals. The service of the petitioners, apart from the primary duty of vigilance and mobilization, were also utilized for various social purposes such as construction of roads, dams, dikes, schools, buildings, repairing and renovations in different villages, so that the petitioners become acquainted with the villagers. Paragraph 6, that the petitioners had to undergo refreshers course at regular intervals, and such courses were held at different camps at Barpeta Road, Rohingya, etc., etc. Amongst the petitioners, some were designated as group leaders under whom as jurisdictional area was fixed. The group leaders have to report to the circle organizers every month and apprise him about the situation. So kindly come to paragraph 8. The petitioners state that the wages paid to your petitioners were in different categories, namely rupees 30, rupees 45, and rupees 50 per day, so as to meet their basic expenses and cater to the needs of their respective families. The petitioner's services were utilized for at least 45 days every 3 months. The petitioners were given uniform. They were also required to undergo medical checkup every 3 months. However, such payments have been most erratic. The minimum amount has also not been paid to the petitioners for continuous period, resulting in immense hardship to your petitioners. Paragraph 9, my lord. The petitioners state that so far as the matter relating to the payment of wages to your petitioners were concerned, the same was most erratic and irregular. It reflected that there was lack of transparency and accountability in this said aspect. Paragraph 10. Your petitioners said that there is no specific age fixed for retirement of the ITB and WATS volunteers like your petitioners, and their services were utilized till they are physically and otherwise fit. However, it is seen that as and when the members, including some of the petitioners, had become old, they were discarded. There is no scheme for payment of any retirement benefits like pension, provident fund, gratuity, etc. The plight of the petitioners on being unable to render their services due to old ages become pitiable. Such a position is not envisaged of a person who had dedicated his entire life for the organization in the maintaining the integrity of the country and checking external aggression as well as prevention of smuggling and other unlawful activities. Paragraph 13. Petitioners state that the aforesaid inaction of the respondent authorities in the matter of providing retirement benefits to the petitioners and other similarly situated persons in the state of Assam is also discriminatory and is violative of Article 14 of the Constitution of India. It is pertinent to mention that the state of Manipur pension at the rate of 2,500 is being paid to the persons whose services were utilized as ITB and WATS volunteers. Even in the state of Tripura, pension scheme is being followed and similarly situated persons like that of the petitioners are being paid retirement benefits. 12. Your petitioners state that Sashastra Sima Bal, that is SSB, is an organization under the Ministry of Home Affairs, Government of India. That being the position, the SSB cannot be allowed to shy away from its obligations and responsibilities towards its volunteers, like that of your petitioner. It is an established principle of law that pension and other retirement benefits are not bounties, but are legal rights of the person concerned. A welfare state cannot disregard its duties and obligations towards well-being of the citizens whose services have been utilized till the period when they were physically fit. 13. Petitioners state that their grievances have been placed before the various authorities through a charter of demands and a memorandum. The plight of the members serving as WATS volunteers and ITB were stated in the same. The lack of basic amenities, including dwelling houses, was also highlighted in the same. 14. I will skip the paragraph 14, my lord. Lordship will come to page 16, my lord, which is very much relevant for adjudication of this matter, my lord. That this honorable court was pleased to pass a judgment and order dated 28/1/2013, directing as follows. The operative portion of the judgment is extracted, my lord. I am reading out the operative portion. In the circumstances of the case, the prayer made by the petitioner appears to be reasonable one. The court is of the view that the above prayer requires a sympathetic consideration of the authorities. For that purpose, respondents may have to prepare a scheme on similar lines as directed by Himachal Pradesh High Court for absorption of the petitioners and also for payment of pension or for providing some financial assistance to those ITBs and WATS whose services were subsequently discontinued or would be discontinued by SSB on account of physical ground, considering the past service rendered by them. Accordingly, this writ petition is disposed of with a direction that the respondents may consider framing of a scheme for pension or for any other financial benefit for ITBs and WATS volunteers whose services are discontinued on physical ground. It is hoped and expected that respondents shall examine the matter, giving due consideration to the grievances of the petitioners and take a conscious decision within a period of 6 months from the date of receipt of the certified copy of this order. Writ petition is accordingly allowed to the extent indicated above. My lord, will find the judgment dated 28/1/2013 in page 13, my lord, annexure 1. This was the judgment passed in the earlier litigation, my lord. My lord, kindly come to page 17 of the writ petition, my lord. the ingredients,
So what do you want here? What do you want in this writ petition?
my lord, in line with
in
the,
that writ petition,
yeah,
respondents were directed to consider framing a scheme
yes,
in line with the,
yes, my lord.
that was considered.
That was considered.
It could not be done. You file a contempt was closed.
No, my lord. There was no contempt.
Contempt was filed.
Content was in another.
It is in the Himachal Pradesh case,
Oh.
not in this case, my lord. Since, my lord, another two paragraphs, my lord, if I read, my lord, everything will be clear.
Okay.
My lord, page 70, my lord, paragraph 70.
Hmm.
The following ingredients are present in the aforesaid judgment in form of direction. Roman paragraph 1. Consider framing of a scheme for pension or any other financial benefit for ITBs and WATS volunteers whose services have been discontinued on physical ground. The matter has to be examined, give due consideration to the grievances of the petitioner and take a conscious decision within a period of 6 months from the date of receipt of the certificate. Though the said judgment was an intra parte one, the petitioners forwarded a copy of the same to the respondents for due compliance. My lord, this is the ingredients of the judgment dated 28/1/2013. Now, my lord, kindly come to paragraph 18, my lord. My lord, to the utter shock and surprise of your petitioners, the Ministry of Home Affairs, Government of India, through the Director General had passed an order dated 29/5/2013 in purported compliance of the judgment dated 28/1/2013. By the said order, the relief claimed by the petitioners have been rejected, my lord. And the lordship will find the copy of the judgment, my lord, annexure 2, page 35, by which, my lord, the respondent authorities had rejected the relief, my lord. My lord, kindly come to paragraph 21 of this petition. That after the affairs had resettled in most ironical manner, the respondent authority has held that the relief cannot be provided to the petitioners on the following ground. The grounds on which, my lord, the relief sought for was rejected by the respondent authorities, although it was directed, my lord, by the previous in the previous judgment, my lord. On the following grounds, my lord, ground number 1, the scheme of training was purely of voluntary nature with no contractual service obligation. This is one of the ground on which the prayer and the relief was rejected, my lord. The monetary and other privileges at the relevant point of time as prescribed by the government had been paid to them according to the respondent. And relaxation in upper age limit by 3 years in respect of ITBs for recruitment to the rank of constable. Cases of ITBs and BVF, Village Volunteer Force, are not possible to be equated as both were raised under different schemes. The Roman 5, the words of the petitioners are free to compete in any recruitment. On these 5 grounds, my lord, the prayer and the relief sought for in the early, was rejected, my lord, which was directed in pursuance of the earlier judgment, my lord. Now, my lord, kindly come to page 9, my lord, paragraph 22. That, my lord, the aforesaid 5 grounds for declining the relief to the petitioners and the similarly situated persons in WPC number, the earlier petition number, my lord, 2281/08, are absolutely perverse, incoherent, and reflects total non-application of mind to the issue in question, In fact, the impugn order reflects willful and intentional disobedience to the order of this honorable court dated 28/1/2013, by which the direction of this honorable court are sought to be circumvented in the guise of the present impugn order, my lord. This is the order impugn.
Just for a moment. Lordship has seen paragraph 22. Lordship. If he was at all aggrieved by the non-compliance, he could have filed a contempt petition at that point of time. It does not mean that he will again come up raising the same issues again by way of a writ petition. He did not do that. I'll come to what was done. I'll come to that. Let him finish.
My lord, kindly come to page 9, paragraph 23. ma'am. That at recital of the impugned order leaves no manner of doubt regarding the perceived mind of the respondent authorities in attempting to deny the legal entitlements to the petitioners. There is no fair, dispassionate, and genuine consideration of the case projected by your petitioners in their representations, which was directed by this honorable court in the order dated 28/1/2013. This honorable court was pleased to pass the direction for consideration after taking into account all the relevant facts and circumstances, including the discrimination which was apparent on the facts of record vis-a-vis similarly situated persons in the state of Manipur. That your petitioners state that the first ground that the scheme of training was purely a voluntary nature with no contractual service obligation is, to say the least, atrocious. A welfare state cannot shirk its responsibilities towards the citizen in the manner as sought to be done in the instant case. That the second ground regarding the payment of monetary and other privileges to the petitioners at that point of time has got nothing to do with the cause espoused / connected with the present litigation. The respondent authorities are trying to divert the principal issue by bringing in irrelevant facts. Likewise, the third ground has been taken regarding the relaxation in upper age, which is also not the issue in hand. On the contrary, the impugn order has failed to address the principal issue regarding framing and implementation of the schemes for grant of post-retirement benefits, which was the main ingredients of the judgment dated 28/1/2013, earlier in earlier litigation. Will kindly come to page 10, paragraph 26. The petitioners state that the grounds of discrimination, which is sought to be addressed under serial number Roman 4, are without any basis and cannot be said to be that of a reasonable person. No intelligible differentiation has been made to be cited between the ITVs and BBF. Further, there is no nexus of creating two different classes to reach any object. The observation made under point number Roman 5, that petitioners are free to compete in any recruitment process. The allegations of the petitioners that there has been no application of mind while disposing the petition. The respondent authorities completely lost sight of the fact that the petitioners are aggrieved by non-formulation of a scheme for their benefit of the persons who had served in SSB as ITVs and what's, my lord. Under these circumstances, my lord, facts and circumstances, my lord, the impugn order, my lord, dated 29/5/2013, issued by the Director General,
Where is the
SSB,
order?
my lord, page 35, my lord. By this impugned order, my lord, the main issue has not been addressed, which was directed by the earlier judgment. So my respectful submission is, my lord, that impugned order was passed by the Director General, SSB, should be set aside, my lord, as it totally failed to address the primary issue, fundamental issue, which was directed by the earlier judgment. my lord.
How were you recruited? When were you recruited?
They were recruited in different times, my lord, and
What time? Which year?
after 1961, my lord, after the Chinese aggression, in different period of time, my lord. About it.
Any recruitment order is there?
Let me check, my lord, in the earlier round of repetition. Some of them were appointed in 1970, my lord. Certified as Sri Ratneswar Dayamari, so and so forth.
Where's the order?
But in this second round of litigation, my lord, those certificates are not annexed, my lord.
No, the first writ petition was filed by you or by some of your colleagues?
By us only, my lord. There were 248 number of petitioners in the earlier round. Since, my lord, the judgment was not implemented, my lord, and not acted upon, my lord, this fresh petition has been filed.
By how many petitioners?
In this, my lord, 3 petitioners on behalf of the president and maybe general secretary, my lord, of the.
How can you say the president or the general? secretary? These are
Individuals,
by way of 3 individuals only.
Earlier, my lord,
No, I'm not talking about earlier, I'm talking about the present writ petition. These are filed by 3 individuals. At least you could have shown some of your, at least the 3 of you, you can show your recruitment order. Do you have a copy of the recruitment order of these 3 writ petitions?
but I'll have to check, man. Definitely will be there, man.
Then you check up and come later on. There's no point in proceeding further. When do you want?
Mm. No, that's
On request made by Mr. S. R. Rava, Leonard Counsel for the petition. Which after? 1 week, 2 weeks?
my lord, just a minute, my lord.
Apa is नहीं करो.
So the Wednesday.
28,
28 তারিখ
28, my lord.
28 may be difficult is the last. We can go to April. 2nd April.
Yes.
2nd April.
19.
Obliged. Your Lordship, in this case, the petitioner was appointed as a armed constable as Assam Police Reserve, and then he was dismissed from service. The main matter was that before dismissal, he was given a so-called notice, which he duly replied to, but he was not given a copy of the departmental proceedings, which is mandatory under the Assam Police Manual, Rule 66(3), Lordship. So in the affidavit opposition, the other side has also admitted they do not have any record of the DP proceeding. The earlier order of 2 of 24, Lordship, this Honorable Court has already observed our submission, and our opposite party was instructed get the updated instruction, Your Lordship.
Yes.
Today, Lordship, the time may not permit your Lordship to take up the matter.
Do you want some other day?
We are ready to, Lordship, but if time is not, then wait.
Yeah, Mr.
J. Das.
J. Das. On request made by MS Bhattacharjee. When do you want? Bhattacharjee?
Any date, Lordship, we are ready, but as the
Short date maybe, Your Lordship.
Don't take next week, all full.
Actually, Lordship.
We'll have it on 4th of
So-
April. 4th April.
Okay.
I'm giving you a date.
Okay, obliged, Lordship.
Yes.
4th April.